Starting our second day of our symposium on constitutionalism under different conditions. And let me just say welcome to some of the new participants who haven't been here yesterday. So first we have Stante Gatmaitan, who safely arrived because no one expected to have a coup d'etat 3 days before the conference. And we have BENOLIEL from the law faculty, who will be first discussant of Antonia's paper. And actually we're continuing basically just as yesterday. We start with a discussant that usually speaks for about 10 minutes or so. Then I will approach the authors themselves if they have anything they want to say, to emphasize, to comment, or if they want to direct the participants to certain issues they're struggling with. And then we will open the floor to the other participants. And I encourage all of you to speak freely. We would like to hear as many points of view and perspectives as possible. And then at around noon, we will have a long lunch break with a poster, with special poster sessions, with poster presentations. So, without spending any more time, Richard, will you share this panel?
Yes, thank you. Just two short notes before we begin. One is, please try to use the microphones when you're speaking. Those of you who are close to this apparatus don't need to use the microphone because it will capture your voice. But I think we have a microphone there, a cordless microphone that Yaniv has that could be used for speakers on this side and that side. And then there's a microphone over here that could be directed to whoever is speaking on this side. So Danielle, perhaps you should have the microphone when you begin to speak. The second quick note I wanted to make is to invite someone among the group. If you want to write a very short report on what we have done at this gathering for publication on iConnect, which is the scholarly blog of ICON, just let me know. And we'll be happy to publish that. Maybe 700, 600 words or something, just going over some of the themes and the who and the what and the where. I think it'd be interesting to share with the world, with the community of public law scholars, what we've been up to over the past couple of days. But with that, let's begin our first panel of the day on economic and financial crisis. Our first pairing is Antonia Baraggia and Danielle BENOLIEL, and I'll ask Danielle, please, to discuss the paper. Thank you very much.
Thank you, everyone. Thank you, Richard. And thank you, Tony, for a very interesting paper, a very timely one. The paper's argument is that in comparing the attitudes of the judging austerity measures adopted by the emergency circumstances of the 2009 Eurozone crisis, Antonia shows cleavage, tension between two set of institutions. The first are the national constitutional courts, which play the fundamental role in counterbalancing the executive power in adopting austerity measures on the one hand. Yet on the other hand, Antonia explains quite adequately how the Court of Justice of the European Union, the CJEU, avoided judging the legitimacy of the bailout measures by representing a sort of a black hole, right? In the EU legal framework and overall breach of the rule of law. I want to make two observations, main observation as to the paper, while arguing that at the outset, obviously, it's a well-written paper. It's a fantastically well described story of how the Court of Justice of the European Union actually acted, and I think should be complimented on what you have done. That said, I have two main observations, critiques to the paper's argument, whereas what I want to try and argue very carefully is that the 2009 Eurozone crisis is, to a large extent and to a partial theoretical extent, not only a fiscal crisis that merits an emergency provisions and the backing of a theory of emergency, but also a predated in ongoing constitutional crisis due to lack of sound economic governance, which predates and exceeds emergency policy alone. And that would mean that if, as I will try to explain, not only did the EU treaty was violated before and during the Eurozone 2009 crisis, which was a story of which presided within a story of normalcy dialectic, which partly mitigates the need for emergency exceptionalism, but it was also, but not only, a story of emergency within the story of the other part of the normalcy exceptionalism dialectic, namely a story of emergency within exceptionalism or exceptional conditions. So to be more clear, it was, as you explained quite adequately, a story of the need for emergency analysis, theoretical analysis of a story of exceptionalism, whereas I want to try and argue to the point I'll make here, that it was also part of a normalcy story within the normalcy exceptionalism, the dialectics, which was avoided I think in the paper, and I'll see why that might help you. And so in justifying what I'm trying to make simply put, which is it's also a sort of normalcy within emergency, not only exceptionalism within emergency, I want to make one argument within emergency theory, and then a second argument within economic crisis theory. So it goes like this. As to emergency theory, just all be reminded by the three rationales, right, of the EU fiscal incentive system, which is an ongoing incentive system that predated 2009 and matters for the conclusion. It's not an exceptionalism story, but also an exceptionalism along the lines of a normalcy story altogether. So it's the three following incentives to create these incentives for EU member states to run excessive deficits in state debt, to prevent moral hazard and overspending and lending in good times, and to protect taxpayers of the other more prudent member states before and during the crisis, not only during the crisis in a time of exceptional conditions, so to speak. And with that said, the three rationales have seen witness to the following core arrangements, which are part of the argument, namely that it's a story of an ongoing crisis as opposed to a crisis that starts in 2009, and hence it's a story of normalcy within emergency. So convergence criteria, which stands for the first set of arrangements, are found in the protocols of the EU treaties that contain so-called convergence criteria, whereby states must abide by a gross government debt to GDP, the debt to GDP ratio that should be less than 60% of the GDP. Secondly, the annual government budget deficit should be less than 3% of GDP. And yet around 2005, namely 4 years before the crisis, most countries, not only Eurozone countries, but most European countries, not to mention Western Europe, most of the Western Europe, including Germany and France and Britain, and obviously the pigs outside of Greece, but also Portugal, Spain, and Ireland, and not to mention the whole of the entire Southern Europe, were all part of this major violation of these two convergence criteria, which I just mentioned. And so not only were these Eurozone members along the lines of many other European countries, by the way, not only in Europe, violating these two fundamental provisions, but no action was taken given these violations way before the crisis erupted with the magnitude we obviously want to focus, which is the magnitude of 2009 henceforth. Moreover, I want to mention the no bailout clause, the three violations that again are violations of an ongoing and of a broader context than just a crisis and the exceptionalism dialectics of a crisis and of a theory of emergency. It's more normal than exceptional, so to speak. It's not only exceptional, it's also to some degree also normal. It's kind of a normal, twisted normalcy, so to speak, that is therefore changing to some degree the way we should, criticize the behavior of the courts. And so the bailout clauses, just to mention, Article 125 of the Rome Treaty that stands for the first and foremost violation of the no bailout clause, which was violated, and we should say it out loud, whereas just to mention, Article states that the Union shall not be liable for or assume the commitments of central governments without prejudice of mutual financial guarantees. Furthermore, Article 123, just to mention, the European Central Bank's purchase of distressed country bonds, again, stands for an ongoing violation and predated 2009 of what they are, therefore, prohibitions of monetary financial budget deficits. Then obviously comes the question of lending, again, a set of violations that start with Greece, but then don't end with Greece and don't start in 2009. It's earlier than that. It's an ongoing twisted normalcy, so to speak, of the way the institutions have decided to go about a financial situation. I wouldn't dare to say definitely crisis as of 2005, but it was a situation, a normal, so to speak, situation that predated the crisis. But was it a case of emergency? After all, comes the question whereas there is one section, namely section 122.2 of the Treaty of Rome, of course, that should have been used if emergency erupts, after all, in 2009. And just mentioning Article 129, I'll just add and say that while scrutinizing the way it was referred to in 2009, the conclusion is quite a simple one, is that it was not used. Article 129 that they actually gives the context for the usage of emergency, the emergency clause for the usage of emergency provisions was not used. I just mentioned that the article stands for allows exceptional bailout provisions in financial situations where a member state is in difficulties or is seriously threatened with severe difficulties caused by natural disasters, obviously non-relevant, or exceptional occurrences beyond its control. We should mention that even Greece itself, the government of Greece in 2010 did not relate to Article 122, again, making a claim that it's not really a sort of emergency, and so it's not sort of exceptionalism within the theory of emergency. That's point number one. Point number two is that there was no council decision because when it was discussed, it was quite clearly understood that there was no cause for exceptional occurrences beyond its control within the context of 122. So, as we said, it's neither Greece or the council that think that we should actually use the emergency clause, so to speak. It's not an exceptional situation, and that was quite straightforward said in put into action by the council. So that's one point very clearly, very shortly, which is the point that comes from within the normalcy, exceptionalism dichotomy, to suggest that we have some degree of normalcy, which is part of the big story. If that is the case, the way we should scrutinize courts should be, assuming a certain set of assumptions that can derive from that type of conclusion, intended conclusion. So that's point number one. Point number two comes with economic crisis theory, and here I'll be really brief. There are two competing traditions, and so if you want to take the same argument from an economic perspective as opposed to a classic, relative legal perspective, economic crisis by and large are defined by the two traditions in economic theory as periodic, systematic, and unexpected, whereas 2009 was neither non-expected and was not necessarily periodic. So again, that's a theoretical economic argument which you should consider looking into. And so that would be the headline of the argument, just to be a bit more concrete. Liberal economic theories that start with Hayek and inspired by the Austrian school, led by Ludwig von Mises, challenged by Keynesian post-2000, 1930 Great Depression interventionist economics, which again have defined economic crisis somewhat differently than what happened in 2009. That's point number one. And then as to second tradition, point number two is that the business cycle taxonomy, which is the alternative tradition within economic crisis theory, again stands for similar type of analysis, therefore saying that it's not, if again to carefully and tentatively reflect on 2009, it's not necessarily the definition of an economic crisis, more of a definition of obviously it is to some degree an economic crisis, but it's not only, it's an ongoing crisis that has not been pinnacled in 2009, so we should maybe model it differently when we think about the role of courts. just mentioned Ragnar Frisch and Viktor Zanovich, with the names you would look into business cycle taxonomies, model economic crises, and what comes and predates economic crises such as in our case. So that's it. Thank you.
Thank you, Danielle. Antonia, do you have any thoughts in response, perhaps? Please.
Thank you so much for your comments.
Could you perhaps move the microphone over to Antonia? Thank you.
Thank you very much. And your comments, the discussion I have with Professor De Witte, which told me that this crisis was not a real emergency situation which led to a constitutional mutation, but just an institutional variation. So it was a normalcy situation. And this is very, very interesting for me, this dichotomy, exceptionalism and normalcy. What I would like to study in that is that, okay, we can read this crisis in the term of normalcy, but at the bottom of this, there is the flaws of the entire system, because when in the Treaty of Maastricht we divided monetary policy and economic policy, and this is, I think, the original theme of this kind of structure. And in this crisis, it came out strongly, the dichotomy, the separation of economic policy and monetary policy. So yes, we can read this as normalcy, but I think in the light of these original flaws of the EU structure, of the EU economic governance. So now we have to discuss about the reform of the EU economic governance, because we have seen that facing this kind of crisis, okay, we can discuss about the proper term of this situation, if it's a crisis, if it's an emergency, but it showed the lack of legal instrument within the treaties. You are right when you mentioned the emergency provision of the Treaty of Rome. Some scholars try to foster the application of this kind of provision, but the reason was that even in Greece, for example, the government knows that there was a problem in their finance, so was not an exceptional circumstance, unexpected. They know that there were serious problems in their financial system. And okay, no, even the second part, the second argument about economic taxonomy, financial taxonomy, is very interesting for me because it's not my field of research. So I would like to discuss more with you about this perspective, which can shed light on my argument. Thank you so much.
When you have a question or comment, just put your nameplate up like this, and I'll be happy to recognize you. Danielle, please.
One sentence only. It's ad absurdum to take the claim, to use the claim that Greece 2009 is a crisis, begs the question: is Portugal, Ireland, and maybe Spain 2016 is a crisis? Why not? Obviously, the answer is magnitude. But then, was the magnitude of the Greek crisis in 2005 so different and fundamentally different than that of, let's say, Portugal in 2016? Question mark. Not necessarily. And if the answer is yes, so we have a clear case of exceptionalism. If the answer is not necessarily, so we don't necessarily have a question like exceptionalism, but something different, a different amalgam.
Yes, of course, please. But let's make sure we have the microphone.
I'd like to stress is that in the EU, the problem was that the 2008-2009 crisis was tackled using instrument outside the legal framework of the EU. This is a very strong point because we use international law. We call the IMF entering in the relationship between the EU institution and member states, and we applied conditionality. We brought conditionality from the IMF and we put in the treaties with the revision of Article 136. So I see in this way of action of the EU a kind of exceptionalism, because otherwise we can apply a provision on emergency, the provision of the treaties, but the EU look at the international framework, and even the first mechanism was a private company based in Luxembourg. So this is a very big challenge for the EU legal system. And even the role of court, because I was focused on the role of courts, are influenced by this kind of instruments, because the Court of Justice, in a way, refused to tackle with the nature of memorandum of understanding, and I think it refused also because there is this international component, international law element that escaped from the EU legal system. So maybe I can read this twist. The German scholar called Ersatzunionrecht. So a kind of another union recht, not union law, sorry, which is not properly EU law, but is a kind of. And yes, in this, in the response to the Euro crisis, I can see that it's not completely normal. See what happened.
Ming Sung?
2 points. One is a follow-up on the debate between whether the debate as to whether the Euro crisis should be viewed in terms of normalcy or exception. I think Antonia has also made the point, but yes, in terms of those outside EU mechanisms being created in response to the Euro crisis, the rationale behind it is to appeal to the sovereignty attached to member states in public international law. As a member, as a sovereign state in the international legal order, the member state's capacity is assumed to be complete and comprehensive. So this allows the member states to go beyond the enumerated powers conferred on the EU. So I think the very creation of those new mechanisms could be seen from the perspective of appealing to sovereignty again in response to the Euro crisis. That's my characterization of the exceptional character of the responses to the Euro crisis. Then my second point, I remember in my paper, I think the conclusion was that there were 2 issues being raised about the paper. First, expert, and then judicial review. So I want to, I think this is a very good link to the issue of judicial review. Antonia in the paper noted, in terms of the EU's CJEU's response to the Euro crisis, basically it shows definitely the decisions taken by the ECB or even the European Commission. On the other hand, the national courts are more record is more mixed, and I think this might be. There may be a good explanation behind this distinction. In my view, this is the very ambiguities about exceptional state of exception being set in the multi-level governance structure. Just when it's set in such a multi-level governance structure, it opens the possibility and the limitation. On the one hand, we said, well, just because of the dispersion of the decision-making mechanisms through the multi-tiered governance structure, hard to hold the national executive to account because they could pass the responsibility to the supranational or international technocrats. And so if we view state of exception at the multi-level structure from this perspective, then we may say, well, this creates new challenges for constitutionalism. But on the other hand, just because maybe we can go back to Kashmir in a different way. I mean, when Kashmir could point out the dictatorial executive could be trusted to make such exceptional decision. I think at least there was one assumption that the national executive must command some political support from the people, whether it's based on emotion or reason. But at least at that very moment, some political support must exist to support such a claim. But in the supranational or multi-level governance structure, on the one hand, the national executive would pass the responsibility to others, but on the other hand, those who have the power to make decision on the supranational level just lack such political support, and this opens the door for judicial intervention. We know in traditional constitutionalism, the reluctance, or we have attributed to the judiciary to intervene in emergency measures, has to do with the legitimacy, the relative legitimacy between the political branch and the judiciary. But in such multi-level governance structure, this becomes no problem. This is no longer a problem for the judiciary because the national executive has no higher legitimacy claim compared to the nation. So this may open the door for the national judiciary to intervene. But when it comes to the CJEU itself, as far as I understand, the CJEU or the ECJ has been characterized as the partner for the unfinished integration European EU project. So this may find the CJEU in the face of such exceptional situation. in this case, showed deference to the ECB. That's my sorry for the long.
No, let's get another comment, and then if Antonia wants to say something, Ellie, please.
Yeah, just follow up to make some very important points, two issues. Deference. We have two kinds of deference, and this is quite interesting because we have deference, and we know that in extreme conditions or emergencies, courts will tend to be deferred. But we have two kinds of deferences. One is within the discretion. You know that the authority had power to make a decision, but to make deference because you don't actually interrupt or interfere with the discretion. And here we have totally different kinds of deference. Deference that is deference of illegality. Okay? The question is not whether the discretion was exercised reasonably or within the substantive rule of law, but it was exercised outside the rule of law, and still you have deference. I think we should make this distinction. The second interesting, I think, phenomenon here with regard to the whole story, without getting into the details of the economic crisis, whether it's normal emergency. But if we take the distinction that we made yesterday between emergency within the rule of law, and you had an avenue here, there is a possibility to declare emergency according to Rome, but no, they didn't go into the rule of law, they went to the exception. And this is quite interesting because one would have thought that if you have the power within the legal framework to address the problem, the specific problem or other problems, you will go first to the emergency within the rule of law and not to the exception. This is something that is interesting from both positive analysis and of course, and when I think about it, with all our emergencies in Israel, we never got to the situation that we get to an exception.
Almost once.
Maybe once, but since we regulate emergency within the rule of law, and the policymakers will think 3 times before they actually go outside the framework. And in the EU, it seems that it was much easier for them to go to the exception than to the emergency. This is quite an interesting phenomenon.
Is it right on this point?
Right
Please.
on this point, but maybe Yanis will comment as well on this point. So, okay, thank you. So what I want to talk about, to the extent that I think 122 is more complicated, was stated because it requires a state to prove that the situation was beyond its control. If it's not a natural disaster, then it was beyond its control. Now, a lot of the economic stuff, and this is what SUHA talks about in her research as well, a lot of the stuff is within the control of the state to the extent that it can do a lot to mitigate the economic crisis. And I think everybody realized that once you go 122, there's going to be litigation, or there might be litigation, because you invoke a legal structure on whether, to what extent you could have mitigated and contributory negligence, and okay, so that it's just messy. But there's, I want to actually draw a distinction following your other comment on exception versus regulated emergency. To draw an interesting conclusion or continuation from the situation in Cyprus at the national level. Because in Cyprus, this is what they did. They said necessity, and they developed a parallel side-by-side, let's call it, a venue to continue dealing with a situation that in and of itself may or may not be a crisis. But what made it into a crisis was the inability of the legal system to accommodate, and then you had to the court had to develop an extra legal venue. Now here comes the question of whether the EU at the international level is unique. Because one can say, huge rule of law problem because the EU is a legal structure, and we don't, what you're talking about, an extra legal venue that they did, and then the court says, fine, we defer, you can do it. You can understand why the court did it, as you stated, because the court wanted to keep people together, and that was the necessity. Otherwise, it would have been legal, huge centrifugal powers to throw states apart. Or we can say, that, no, it's not a legal crisis. Why? Because you have those residual powers of sovereigns, and they just created de facto a parallel treaty, sort of like a parallel international norm. And these two norms exist parallel because it's international law, it's not constitutional law. So our entire structure, we haven't dealt with that aspect, our entire structure of what do we mean, how to think about this. I think this is the main challenge for us, because violations of the law, as Danny stated, violations of EU law started into way before that. Everybody, so we have state practice. A state practice that we ignore those parts of the treaty, and we act in parallel, and therefore, you know, how should we think about it in terms of our idea of exception?
The first point that I'd like to make is that we should not think very narrowly of the rule of law, particularly in the EU context. We could probably think of these cases with having in mind McCulloch versus Maryland, the bank case, where the court says that it is a constitution we are expounding, and it took and interpreting the necessary and proper clause, it took into in consideration the purposive nature of forming a closer union in the case of the in case of the U.S. Constitution. This is the first point. We have to take into account the idea that the EU evolution has this dimension of complementing and evolving the structures according to the circumstances and the necessities that appear. The second point, however, which is a complicating factor, but an important one, is that we have to also take into account that the EU, constitutionally speaking, has two ways of evolving: the intergovernmental method and the community method. Now, the intergovernmental method employs treaties between the member states, and as a consequence, this wouldn't be something alien to the way of evolution of the Union to have an intergovernmental treaty, which actually, once it is tried, it takes the form of being incorporated, of incorporation within the basic structure of the Union as community law. But it starts as an intergovernmental treaty. So this is the second point that has to be account. Now, from this scheme, the situation we are discussing is different in the following factor, which is crucial legally, that the IMF comes into the scene, and the IMF breaks with this pattern of evolution. And by bringing the IMF, you create a structure that it is non-cognizable from the point of view of sources of law. The legal system of the way that the constitutions and the EU structure their evolution and their relations is based on certain principles which take into account the intergovernmental method, take into account the supremacy of EU law, but not this creature where the IMF acquires so important role. And this makes for the courts and creates for the courts a novel situation. They cannot really place on the hierarchy of norms this element which creates contradictions, because if you see the way that the treaty and the international treaties and the intergovernmental, international law and EU law from the point of view of constitutional law is something which, if you try to place the structure that is created as a result of the measures on the ground, on the scale and on the pyramid, you won't have an easy and rational legal solution. So under the circumstances, the courts face a situation which is a typical, the archetypal situation of political pressure and restraint. What would be which would say that I will interfere in advance and resolve the matter before letting the life make up its mind about what's going on here? We don't even know today what's going on. The idea of having the EMS obtaining the role of a guarantee of the preservation of the stability mechanism out of the community and placing it in the hands of the EMS, that would create a totally new constitutional structure in terms of the EU. Because you would, instead of having a structure which is based on the community principles, which are in principle federal principles, the EU law is in principle an expression and a reflection of the principle of federalism, not of the system of federalism, but the principle of federalism, very differently. You would go from a principle of federalism, which is a public law constitutional issue, you would go to a mechanism which is a corporation of shareholders, which is a totally different rationale. So these things are not for the court to decide before political sovereigns decide them for themselves. That's what I would say. It's a question of political legitimacy and democratic legitimacy.
Thank you, Yanis. Let's get the microphone to Anna, please.
Good. Yeah, I just, because I think this is the evaluation of if it was an emergency, highly complicated. I really never understood what happened there and what's going to happen. And because I just really lack the expert knowledge. And when we were talking yesterday about that, what I found striking is that even the experts were not capable of answering the question of emergency. However, what I just remember is that this wording in German was used for the banks as well, both was prior to the crisis as well. System relevance, so the system relevance of the banks, for example. And I was wondering if one day I would be relevant for the system, maybe, which would be the biggest achievement in my life. But the thing is that
you have to study Luhmann system theory.
Yeah, I think to get there. But I was wondering if indeed maybe, and this is just really, if maybe because you put judicialization in dots, maybe we should put emergency in dots as well. Because I find it really a tricky situation. However, the other thing is, what is different in the situation, in the role of the, especially of the ECJ and the courts in this situation, that the development of the European Union law, it was always, the court it has been from the beginning, it has been judicialized. So without the European ECJ, we wouldn't have been, the European Union law wouldn't exist the way it does. So indeed, it is maybe an interesting question. What is the difference that now the court stepped into it? And I think in this regard, because indeed, and of course, what Janis as well said, but I think in this very, very second, they did step outside the rule of law. They did, the former rule of law. And there is, of course, the estimation and the court situation and the economic, it's very complex. What else could have been done? I'm not sure, but I think if you just read at this very second, the decision when it was made, the first one, I think it was outside the treaty, the wording of the treaty point. So if they did, they did it outside the rule of law. And I think on the national level, however, it would be discussed under the word of constitutional change. And what they did is actually they changed the constitution. They did a constitutional change. And indeed, I kind of think about the situation where else that happened, also within the German jurisdiction and for the Bundesverfassungsgericht. I think maybe it would be the decisions, for example, but it was not a crisis, it was a decision about the employment of military outside the German territory. Not a crisis, but a decision where you would say this is a constitutional change, what we did. And then the second was the Aviation Act, constitutional changes. But, that's not relevant for your paper. But I think that would be an aspect that I think on this level, on the national level, it would be, the tag actually treaty change or whatever. And then, so that's okay. I think that's it.
Good. So the end of the session. Daniel, thank you very much. Antonia, thank you very much. Let's move on now to the second paper in this first session. SUHA will be commenting on ELISA's paper.
Good morning. Should
I think you're okay.
I'm okay?
This will be able to hear you.
Yeah, all the others are hearing me. So, okay. So it's funny how I was listening to the argument, and we could actually combine the discussion on both articles together, and as well as the comments and questions being asked. So I hope I won't be repeating part of the comments that were said right now. Now, the paper. Page 1. Yeah. And so the paper actually also addresses the functioning of the constitutional and institutional mechanisms during the economic crisis in the EU, and examines whether a regular emergency clause is suitable for managing an economic crisis. This is the question that was asked. Two main elements were actually addressed in the idea of emergency. The first is that emergency is a temporary situation, and it involves a shift of authority from the parliament, from the legislature, and from the courts to the executive branch. And the story told is in the article is that there was a crisis that was dealt with outside the regular institutional decision making, both in the EU and both on the EU level and on the national level. The main instrument for decision making was, as we have just discussed, through intergovernmental agreements requiring national adjustments with high level of specification coupled with financial aid. And that decision making in the paper is described as it was neither transparent nor was there was an accountable institution to take responsibility for the social and economic rights that were infringed in the process. And the argument goes on, it says that decision-making revealed the constitutional weakness of the EU, and especially the lack of an adequate emergency clause tailored for an economic crisis. And this is because economic crisis has a longer effect. There was a problem with the temporality feature or element, and also because the executives were weak. Which of course does not comply with the second element, which is that the executive is the one who is acting, and the shift of authority goes to the executive. And I have two main comments. The first comment goes to the argument that the critique that you raised about the decision making and legitimacy or lack of accountability and lack of transparency. And I felt along the argument that there is a normative premise that is opposing to the neoliberal or the liberal story of the economic crisis. And it would be helpful, and you mentioned actually this normative tension, and it would be helpful if you could, if the normative standing point was explicitly argued at the beginning of the paper to guide the reader, because I was always asking myself, okay, if I were a neoliberal, would I find that a problem? And in most cases, my answer was no. So it's very important that already in the beginning, you actually state your normative premise. So the liberal or normative standpoint would see the story in a different way. I think you could argue that the executive weren't actually that weak. They had the full authority to decide, but the weakness goes back to their need to the financial aid. And if you look at it from this perspective, then you would say it's a regular cost-benefit analysis, and a government, especially the example that you bring about Greek, governments actually bowed and deferred to the agreement because it was for their own benefit. So it's an argument that I felt it should be already at the beginning confronted and stated. And you might also want to consider the power relations between the different states within the EU, because referring to the executive as weak has a lot to do with power relations between the different states. And here I could also add an interesting argument that was made, it's not my argument, that fragmentation of international law and the avoidance of the multilateral frameworks actually serves the superpowers, because superpowers are stronger in a bilateral or in small negotiating groups, and the more the framework is a multilateral framework, then they are less strong, because other states can actually make blocks and alliances among them, and perhaps that argument should be discussed while talking about the weakness of the executives and the power relations between the different states. And you could also ask, were all executives as weak the same in the same states? Were all governments as weak, or there were weaker governments and stronger governments? The other note that I would like, it was interesting. I would like to hear from you. It's your idea of social and economic rights, because obviously you have a normative standing point about social and economic rights, and they are central in your paper. So I would like to hear more. What is the minimum that you about social and economic rights? The minimum that you refer to, and perhaps work more on explaining how those rights were infringed. It's a very interesting argument. I personally find myself agreeing with this argument intuitively, but I would like to hear more about how actually they were infringed. Okay, the other comment that I have is about the argument that the financial crisis is not suitable for the regular emergency. And here I will go faster. And here you talk about the weakness of the executive that we have just discussed, and the temporality. And as far as the temporality goes, you say that an economic crisis is not temporal, or has longer effects, and that's why it doesn't it's not applicable to regular emergency. And I would like only to refer to a discussion that was just now mentioned about the difference between normality and between emergency, and also to ask whether obviously an economic crisis has long duration, but when an economic crisis is an emergency, is not is only part of the plan. So you can have an economic crisis, and then at a certain level, the economic crisis becomes an emergency, and then the economic crisis continues, but does not is not an emergency anymore. So perhaps you need also to work more on the idea of temporality, and how do you see it? Of course, the idea of continuing a fight of terror could also give the feeling that the temporal is normal, and here really the discussion was enough rich that I don't want to elaborate more. The other thing is that you have mentioned is the weakness of the executive. I will go back to this point again, because I think that I think that the executive was not as weak as it looks, and here really I find the need to work more on the idea, how do you find weakness, in what sense, legally, were they legally bound, were they politically bound, politically on the international level, on the EU level, or in the national level, because I'm not sure that the problem is actually in the national level. And the last, okay, I have 1 minute. My last comment is about the connection that you make between the whole argument. I like the arguments a lot. They were very compelling in each part of the paper, but I'm not sure that the combination between the different parts is strong enough to say that states exited the emergency clause, and that means that the emergency clause was not suitable for the needs of an economic crisis, needs actually more work to do. It's very interesting to ask why they exited, and we have just discussed different explanations. I would like to hear what's your explanation for the avoidance of the use of the emergency clause in the EU, and yeah, I would again refer to the discussion. I don't want to add my own explanations, but there are alternative explanations, and they don't all lead to the conclusion that the emergency clause is not suitable for an economic crisis. So you might be more specifically on this case, but really a very interesting paper. I enjoyed reading it a lot. It was easily read, and obviously it's going to be a great paper.
Thank you, Suha. Elisa?
Okay, thank you very much for all these interesting suggestions, and thank you also to the previous pairs and to the people who participate, because our papers have lots in common. Well, just to try to address some of the points you've mentioned. Well, one of the weakness of the executives. Well, of course, I didn't refer to all the executives in the Eurozone countries, but I was referring in particular to the executives of the southern countries, so the ones more affected by the economic crisis, so the Greek government, as well as the Italian one. I had particularly in mind the Italian case. Well, Italy didn't enter any bailouts and didn't receive any financial aid from the Troika. However, the situation was quite serious, or the same. And why I sustain that the Italian government was weak. Well, we of course we ratified the fiscal compact. We amended the constitution. Article 81 was modified and in order to meet the requirements of the fiscal compact. But the fact is, so we stayed within the rule of law because we performed a regular amendment procedure, okay? But the fact was that this amendment was performed actually very, very quickly. There was almost no debate in Parliament as well as on the paper. So the public opinion wasn't enough informed. So you were either you were a legal scholar or someone working so close to the institution, or you didn't get the perception of what was actually happening. And I think that if a government resorts to such not a speedy procedure, because that wasn't a quick procedure, the one of constitutional amendment, but however, if you don't firstly, if you don't promote also the civil debate, is because you fear that you actually may not have the support of the public opinion. Okay, so you don't want to outline what may be the consequences deriving from such amendments. So this, I think, is something showing weakness from the part of the executive power. So the fact, and the same goes for Spain. In Spain too, there was a constitutional amendment. The provision will enter into effect in 2020. So it's something that seems so far away in time. Okay, so people, I think, don't get the real perception of what will change. So since 2020, it seems so far away. But still, you didn't have the I think what is a suitable debate for such important issues. So I think that this is a proof of weakness, and of course the fact that the executive in these countries, southern countries mainly, are weak. Is also due to the fact that we have not starting from 2010, so not starting from the breakout of the crisis, but also before, of development of this sort of anti-system parties or political movements that do not pose as political party, but that are against the traditional political establishment. So we see in Spain, in Greece, in Italy as well, and these parties mainly have as the main target the European Union, and what everything is related to the European Union. So you have is growing this sort of detachment. Well, it's always debated that people do not feel very close to the European Union. So that is another of the original sins of the European Union, okay? But now this situation of economic emergency has fostered this gap, this detachment that we have. So we think that all the constitutional reforms or all the financial and budget laws that have been passed by parliaments in the last 6-7 years are something that was drafted outside the national dimension. Okay, so if we have been affected so much by the economic crisis is because of the European Union. The European Union fosters austerity, so it's the European Union that has to be blamed. Okay, and the executive powers, so the governments, are blamed because they couldn't stand before the European Union. That's also the Greek argument, what you mentioned. But what could have the Greek government do? Okay, but to accept all the conditionality was the only way, or has been presented by the government as the only way to try to exit from the crisis. So there wasn't actually no real options. And of course, if your government tells you, well, I signed this agreement because I couldn't do anything different, well, of course, you perceive it as a weak government. My interests and my rights in front of this international leviathan, okay, that's the Troika, so the IMF, the European Commission, the European Central Bank. Okay, so that's what I meant when I said that the executives are weak. So they are weak, both at the national level because they have lose their sort of legitimacy with respect to the people, to the voters, okay, to the civil society, but as well they are weak at the international level because they actually have no bargain force. So because in front of the IMF, well, you can't, if you want my money, you have to buy my rules, okay? So basically this is another point, according to me, that that shows weakness. Well, economic crisis as an emergency, well, I think that economic crisis is an emergency, but it's not a traditional emergency. So basically, the pattern is different from what we usually consider to be an emergency, a state on the state of war, so an attack by a foreign country or a natural disaster. So it is, of course, an emergency, but I think that it needs a set of rules which is a bit different from the traditional instruments that a government can use to face emergency. Again, the case of Italy. We have the possibility for the executive power in cases of necessity and urgency. So, for example, a natural disaster, earthquake, flood. Okay, so to immediately act what is called a decree. Okay, so no need to get through Parliament at the beginning. Okay, so the provisions immediately enters into force because there is a concrete, a prompt action required. Okay, but for an economic crisis, you can't fall that way. Well, governments have tried to adopt the action. They have adopted the law decrees, introducing some major reforms in order to save money and to try to foster economic recovery. Okay, but in particular, the most contested provision was the abolition of the provincial level of government. Okay, so basically we have regions, provinces, and then metropolitan city, well, there was something that at the time was still not implemented, and the municipalities. Okay, so the government wanted to abolish one level of government. The problem was that, according to the Constitutional Court, you cannot introduce a major organic reform through a law decree. So that seemed quite obvious. Okay, so you need the ordinary parliamentary procedure. But according to me, this shows us that the most typical emergency measure of the Italian legal system, which is the law decree, which was drafted having in mind a possible emergency situation, is not fit for economic emergency. So my idea is, okay, it's an economic crisis emergency. Okay, in some cases, at the point the emergency may end. Okay, and you enter again in a normality. But my idea is that you need a complete new set of rules, a sort of new rule of law. Devoted in particular to certain type of economic emergency like this one, because and I was just focusing on the Italian system. The system provided for by our constitutions aren't suitable for this economic emergency. And then you have the I insisted quite a lot on this idea of the temporality of the emergency, because all the all the measures that were introduced in order to fight the emergency, to save money, basically, so cut on welfare, okay, so cut on pensions, cut on retributions, and so on. Well, they do not have a temporary effect, okay. We still nobody has studied the assessment of this. All these measures, so they may have consequences for next decades. Okay, so that's not typical according to my emergency. Okay, that's why I have this idea that we need something. So we need a new rule of law, a different rule of law, and therefore we also need a different system of checks on this on all these provisions. Okay.
Great. So I think there are maybe some comments and questions. Let me ask one to get us started. I see Amnon and Yaniv and Anna. Let me just kick us off, and Pedro as well. You lament in the paper that the debt break amendments, and you just mentioned it in your exchange with SUHA, were passed rapidly without sufficient, in your view, just very quickly. There are in many constitutions around the world, rules against amending the constitution during time. But the emergencies that these constitutions define are not in fact economic. And so what your paper and Antonia's paper are doing jointly together is suggesting a new form of emergency that perhaps could be useful to constitutional designers in thinking about the rules they impose on when the Constitution may be amended. So for example, some constitutions have rules that say you cannot amend the Constitution in a time. And perhaps the same question that you have in your mind, ELISA, about whether, or that was raised to you rather, about whether an economic crisis is in fact a crisis, some have raised that about war. When is war actually declared? When are we actually in war? So there's a parallel between those two. Or when the state is in a state of siege, or is in a period of succession or regency. Constitutional amendments are often prohibited in those cases. And also two other examples that I can think of, maybe Yaniv can think of some others. Sometimes the constitutions prohibit amendments immediately after their creation and also immediately after the passage or failure of an amendment. So what all of these moments have in common is that they're shocks, potential shocks to the constitutional state. And so I think using these examples, you could strengthen the answer that you've given to the fact an economic crisis can be called a crisis. So I'll leave it at that for now. I have some other comments and I'll share with you separately. Yaniv.
I think I knew you were going to answer, so I didn't request, but so from your perspective, the inability to amend the Constitution during crisis or emergency would actually be a bad constitutional design, because sometimes the law that we have is not sufficient to deal with the crisis. I'm just making sure that I got it right according to what you're claiming. Right? So this would go against those constitutions that do not allow.
Well, not necessarily. My point is that simply the way that these amendments have been performed, for example, in Spain and in Italy with such a hurry, of course, following the regular procedures. And for me, it was fine to amend the constitution. However, as I said, this sort of secrecy, okay, that was a proof, according to me, of the weakness of the executive power. That was simply my claim. Not that. According to me, yes, it was good because we may had a negative fallout of after this constitutional amendment. But however, we can also think in perspective that creating more strict rules, if of course then the government has to abide to these rules, may in the longer period, not in the short period, but in longer period, may be an advantage, of course.
ELISA, just to follow up on this, and then I'll come to Amnon. Is it on this point, this particular amendment point? So just on this point, ELISA, isn't there a tension between the answer you just gave to Yaniv and the second point of your inquiry, which is whether after the emergency has been concluded, is it possible to restore the status quo ante? I wonder if there might not be a tension. We do allow amendments to be made during a period of emergency. The circumstances are, I guess, so tense that in emergency conditions, after with impossible, difficult to revert to the status quo ante. Which is why, that's the way I take on Yaniv's question to you, is why, if this is a concern you have, is it okay from your perspective, your framework, that these constitutional actors were able to amend the Constitution during this period of what you call an emergency? No need to answer, just maybe, I think maybe we should get some more questions and then feel free to make some comment. Amnon, Pedro, and Jonas.
I have a couple of conceptual points and methodological points. So the two conceptual points, one has to do with the law. And here I follow on Jonas' previous discussion. And I think here the relationship to law, I think I would be more interested in what is the legal component in your analysis, and it ties us back to what is the law here, to the extent that there's a bug in the normative pyramid, as Jonas was trying to tell us. From a purely Kelsenian point of view, it's our bug because we haven't identified the sources of flow properly. So you have to revert back to international law and say there's something else that's happening there. We just didn't realize that, or there's a state of exception. You're working outside the law. So I think that it would benefit perhaps your analysis to tell us more about this, within which the conceptual paradigm you work has to do with what is unique about economic. The second conceptual point is what is unique about economic crisis. And this is something that we've been thinking about in the Minerva Center. Within economic language, markets collapse. That's part of the natural structure and cycle, the same as fires from within nature. So an entire forest may burn, and from the perspective of nature, okay, so there is a fire, then the forest will rebuild itself or not. So there's nothing there to be said other than to look at it and say, that's an interesting economic process. Let's understand how it works, or something like. So there's internal to the economic analysis that tells us what is a crisis and what is an emergence. More importantly, what is an emergence? You have to go social. You have to go outside the economy and say, well, if people begin to have riots on the streets, if people lose faith in their institutional structures of government and take the law into their own hands or whatever it is, so you go to sociology, and you say, okay, now I have a point where I need emergency powers, I need to do something, because it's society. And it tells us back about law, because law has to do with society, it's regulated society, etc. This is not to say that you cannot say powers vis-a-vis the market, because if I let the market continue this way, there is a perception that something will happen and then social forces kick in, so I need special powers. Whether you have them under the law or you don't have them under the law becomes a positive question of whether certain powers are needed. But I think conceptually it requires further analysis. And then the last point will be methodological. Your analysis of weakness, what counts as a weakness or not a weakness, is political analysis. So you deploy political science thinking of what counts as weakness, and here I wonder if it's contingent. It so happens to be that some states are weaker than others, something, or whether there's something more systemic that we can learn about executives in economic say. So you can have capture theories saying, well, executives are actually owned by the market to some extent or some of market force. Or you can have something to say that what is unique about the market is it requires cooperation and a full, we talked about Schmidt, let's talk about Marx a little bit, right? Hello, Marx, all right? So Karl Marx would say, okay, you have the superstructure of that, but then you have the real structure. And what's unique about economic crisis, the real structure underneath it, and somehow, then there will be a re-emergent change of the elites, and then there will be a re-emergence, and what do we think about that? And then you can say, under such a consensus, executives are weak because they represent the old elites and not the new elites, or something meaningful about that that's not just, that transcends the contingent fact of 2009 in Europe, question mark, or maybe not, or maybe it's just, everything is very fact specific, and then you deploy a different kind of methodology. You say, it's just a case analysis, this is what we can know about the world, epistemologically, full stop.
Thank you, I'm none. Pedro.
I'll pick up just right where I'm left person. Now that you mentioned about economic cycles, linking it to the previous discussion, where there's this figure of certain institutions, in many cases due to their expertise, and so, for instance, the CGEU, I guess, exercises deference because it considers that these extra bodies will have better answers than what judges can give. And I also deal with that in the field of the WHO. But the point is, what happens when experts get it wrong? Just as a anecdote, I remember that before the 2008 financial there were some high-ranking officials at the United States Federal Reserve who claimed cycles were over, that they had finally reached stability thanks to the prevailing economic theory. And this was, of course, before the state could claim it. Then it turned out it wasn't like that. It wasn't the way in which they portrayed the gains of currently prevailing economic theory. So what happens when even there are two experts, but experts get it wrong? I mean, they're not perfect, they're human beings, and they could be mistaken, of course. That's no one can claim otherwise. But so what kind of accountability can there be? And if there is an authority given due to this expertise, what can we do about it? And that's, I guess that's a big question. And now in a more specific point, and going back to your second argument, and also to what Ioannis said in the previous section about the legal sources and what kind of challenge this poses. And I think there's a big overlap here between your paper and Antonia's paper with regards to the Pringle case and the CG, and how you both criticize it on the grounds that insofar as this is not legally binding, the ESM's decisions are technically not really binding, and you mentioned it here on page 12, since neither the EU member states or the ESM are implementing union law. So this puts them out of the scope of the charter. And so the CGU says, I'm not going to touch it, and it's not a matter of European law. And you both criticize it. But here the challenge is, as Jan said, even in international law in general, you cannot follow a sources doctrine and claim here is the legal grounds for this decision. So I'm guessing whether you also provide an answer to this, possible answer to this on page 14, where you say, in the narrow freedom of action that is left to member states, in particular those who entered in the memorandum of understanding. So here's the point, and you also stressed this when you said how these institutions act in the way that they say, if you want my money to do what I tell you to do, and you will implement these reforms. Otherwise,
it's a contract.
Yeah, and they cannot force you, but if you don't do it, then you don't get the money. So that's the disguised obligation is, okay, it's not legally binding per se. You cannot follow sources doctrine, and that's what the CGU said. And maybe possibly one answer is provided by Andrea Special-Lascano, as I mentioned in her paper, but why should that stop it from being susceptible to accountability and maybe even responsibility? So I guess that's the policy between both papers and what called my attention with regards to this challenge for us lawyers to go beyond the sources doctrine and say there are obligations here, there can be a responsibility because there is something happening that's, and doing a shameless self-promotion of the work being done at the Max Planck Institute, there is an exercise of authority here, and that's how we are trying to understand these type of phenomena, and memorandum of understandings are an example of how this authority can be exercised beyond the formal legal sources. And so I guess I would see how you both share this line of argumentation in your papers. Thank you for sharing.
Thank you for that, Pedro. Anna, do you have a thought? Could you use the microphone? Just the microphone?
Because I think that's clear. It's defined in the report. But I still would like to kind of refer to what was referred to before, where, because you write that versions, generally speaking, always lead to possible rights infringements or suspension, which is true. I mean, there is always the duty to protect, coming also from a human rights methodology that the state has, to protect life, to protect so on and so on and so on. But now this argument, because I really believe I find it interesting, where exactly we and what rights right here, we didn't do it all in very detail. And however, indeed, I was thinking, what is it? I mean, this, especially the measures the economic crisis taken then. I think this is really different. There is no infringement with in this context, we do not have especially infringement with the right to property. There's no property taken away, or and then your argumentation, the economic and social rights, which is more a kind of duty to protect situation, of course, but maybe this is also a shift. It will be just interesting. I'm not sure if there's more time for
Thank you, and Jonas, please. Would you pass the microphone over to Jonas? There you go.
Okay, thank you. I've been always amazed by the audacity of the legal mind to mock at reality by establishing an imaginary world which has nothing to do with reality. This is what exactly happened when the Greek Council of State rendered a judgment on the legal nature of memoranda, because as you said, okay, when you lend me money, you set the terms, and the memorandum was exactly the conditions and the terms to borrow me money, to lend me money. But the court said that from legal point of view, the memorandum is just a project. It doesn't have the nature of a law, of a legal statute, because it doesn't contain provisions. It is full of conditionality, aims. So it said, I expect the next parliament to vote the measures that implement the conditions, and I will render judgment on the specific provisions that implement the conditions. I will not come here offering advisory opinions in advance to what will happen if it happens and under the conditions that the various stages are fulfilled. And actually, how could the court come and say today what happened in 3 years and placing under me the memorandum of understanding, which is full of stages to be filled in the process, whether they give us the green light to move to the next stage. If they tell us, go away. You know, no bailout. Done. Render it. So this is the first one. But this is, as I said, so the result is that all these demonstrations, the burnings of buildings in mountains happen for something which legally did not exist. Interesting. That's what I said before, the previous comment. What I want, however, to say is that the Euroclass is really fascinating because it places here a more interesting and general methodology, I think. It places the question of whether we should distinguish the deep political conflict which generates episodes of emergency. And I think that this is part of the Constitution. And it seems to me that what is peculiar to this crisis is that we do not have political opponents in the street. We don't have enemies. You don't have enemies because we think of emergencies in terms of profound animosity, isn't it? I mean,
if it's not natural disaster, natural disasters do not
help. I made that point. In terms of, but in my mind, in my thinking, the case of earthquake is not a politically decisive issue in terms of origins. It's different from that. So, but I've already spoken a lot. I want to say, however, that in the case of the EU, what I think that is important is that we had for the first time, the opportunity to cover what Peter Grimm and Jürgen Habermas were discussing previously. That is a European public forum. The citizens of the European countries were informed about the politics of other countries and about the intervention of the EU organs to resolve conflict. For example, I couldn't imagine myself before the crisis reading 3 or 4 times a German press on the internet, which I've been doing steadily. So as a result of that, what we did is we had a golden opportunity to politicize the issues and problematize the issues in terms that would promote the and unification process. And instead, the way we did it with the technocratic language and with the rationale of punishment is we really managed to create a mess and of centrifugal forces, despite the solidarity which was actually shown in practice by the bailouts. That's really something that couldn't be hard.
So we have run out of time, but we have 2 very quick comments, I think, Amnon and Yaniv.
Maybe I don't want to take time of the we can talk about in the break about this business of conditionality also in domestic law. We have some examples like political agreements that are signed within national systems where the courts have then to decide whether to what extent they're legal or judicially cognizable.
I should be honest. I need to rethink Schmidt's enemy-friend distinction. Perhaps we should rethink Schmidt's enemy-friend distinction when it comes to certain types of emergencies. Because public health, I thought about it yesterday, public health, economic crisis, these kind of issues could be a defining factor rather than dividing effect. It's just the point to think.
Thank you. 2 seconds, yes. The microphone.
I want to paraphrase a paper by Mark Dawson, who wrote about what happened in Europe in 2009 and suggested that delegation of power to supranational institutions sum up some of what was said here, actually have made a judicial review exceedingly difficult and a judicial review problem that is beyond the question of emergency. So we have a possibly separate question here that comes out of many questions arguments. So it's a question of judicial review altogether, only for the context of the problem, given the supranational delegation involved.
Thank you for that, Danielle. And thank you to SUHA, and thank you to... So we now have a 30-minute, now 27-minute break. We'll reconvene here at 11:30 for our next panel. Thank you. Thank you for that.
نعمل بقى تتكلم. اوكي خزرتي.
Hello? Do you hear me? Hello? Hello? Yeah.
FATIH?
Yeah.
Hi.
Hi, how are you?
Okay, we're online, so I'm muting you and us, but stay with us, okay?
Okay, you're gonna with me, and then you're gonna ask question, and then I'll answer. That the way it's going to work?
You're now part of our conversation. You are in the room. Let's wait a minute. You see, this is SUHA, and this is me.
Yeah, I got you.
Hi.
Hi, how are you?
Okay, and we are online, so the whole world sees us. I mean, whoever is
Brother is
internet and looking. So what we'll do now is I'll just mute myself and mute you, and when we reconvene, then I'll unmute both of us, and then you can just take part in the discussion.
Okay, that's fine.
Okay?
Yeah,
We're in a break.
yeah, I know.
Okay. I hope I'll manage to have also Ricardo online. Okay, stay with us.
Yeah, I'm here.
Because you're like the key person here. So, but yeah, we'll see when you come back.
20 minutes, I have to meet some colleagues that
Okay.
couldn't meet any other.
Thank you, I'm not.
Yeah.
So let's see what this is. Good. Some cereal. Yeah.
We have FATIH with us. We don't have Ricardo. And we are online.
Well, then you want to start?
Is that right?
Okay, thank you very much, everyone. We're starting the second panel of today, which deals with actors in constitutional change. Now, I think that this panel will truly be under extreme conditions, because the first author is Professor FATIH OZTURK from Istanbul University, who does not join us due to the coup d'etat, but I think he's hearing us now live, so hopefully we could still get some meaningful sort of comments from our discussion. And concerning the second paper, the TILMANN paper on military actors in constitutional change, related to the time, Ricardo Cunha will also not join us because of his flight was supposed to go to Istanbul. But he hopefully will also join us on Skype, and if not, worst case, I will read his comments. So our first will be Guy LURIE from the FATIH, who will give his comments to FATIH's paper, and I hope that they can hear us. Right, please. Professor OZTURK.
Yeah, he can hear us, but we can't hear him until he will unmute his. Shati, can you unmute yourself? Shati, you have to unmute yourself. I think you can hear us, but we cannot hear you. Yeah,
that's us.
He has to do it himself. On the top, the icon on the top. Well, that's technology. Ends with people. FATIH? No, we can't.
Oh, there was something. We just heard something. Say something again.
FATIH? No, you have to unmute yourself. I typed him. FATIH?
Well, if he can hear us, then we can get the comments. Maybe ask him,
Yeah.
FATIH, can you nod if you can hear us? Looks like he's moving.
Yeah.
Oh, can you hear us? Yes. Blink if it's yes. Okay, he can hear us. Okay.
Professor OZTURK's paper obviously comes at an amazingly apt time. Reading the paper to the aftermath of the failed military coup this past weekend gives the impression that Professor OZTURK is simply passive. His paper of this weekend's failed military coup, Professor OZTURK describes what he sees as the greatest flaw of the Turkish democracy. Elite groups of appointed bureaucrats and military officers are ultimately more powerful than elected officials. These elite groups, particularly the military, time and again wrestle control of the government from the elected officials and impose their own vision of a democratic Turkey, partly through constitutional reform. This leads Professor OZTURK to conclude that elites are more involved in political processes than the masses in Turkey, and that the military is above the Turkish constitutional system. The government is ineffective in such a flawed constitutional system, and so Professor OZTURK argues that the constitution must be reformed to allow better civilian control of the military and more effective government. Now, to reiterate, as I read and heard the paper, as I read the paper, I cannot but be amazed by its timely topic. It puts into historical perspective the place of the military in Turkey's democracy, and allows an assessment of how this state of affairs came to be. The question that I am most curious about is this: how does Professor OZTURK see the failed military coup and how it affects the conclusions of his paper, if at all? Beyond this most obvious point of interest, I would like to propose a few comments on topics raised in the paper. I believe the treatise might prove fruitful and could improve what is already a very timely and interesting paper. Particularly, I would encourage Professor OZTURK to add theoretical and comparative dimensions to his largely historical analysis. I will give a few examples. First, I think more theoretical work would be useful for Professor OZTURK's identification of the problems faced by the Turkish democracy. Often the paper conflates issues that I believe should be addressed separately, especially since their treatment perhaps calls for different solutions. Professor OZTURK, for instance, writes that Turkey has been in search of an effective stabilization of state democracy and the removal of Turkish armed forces from the political arena. In this passage, as in other sections of the paper, Professor OZTURK conflates three separate effective government prevention in politics. Does improving the democratic character of Turkey enhance effective government? One could think of various elements associated with democracy, such as representative government, that could potentially stand in tension with effective government. Are the measures necessary for containing the Turkish military the same as the measures necessary to better Turkish democracy? The distinct measures used to tackle such problems in other democracies in the past justify, I believe, the distinct treatment of these problems. The distinction that I believe Professor OZTURK should make between these two goals of achieving more effective government and stabilizing the democracy in Turkey leads me to another issue related to theoretical definition. Time and again, the stability of the Turkish democracy is invoked in the paper. Most understandable military coup. Yet, what exactly does Professor OZTURK mean when he writes about democracy? Does he mean a stable constitution to which everyone adheres? Does it mean some form of limited government? Does it mean a representative government? Does it mean constitutionalism? Does it mean a government that adheres to the rule of law and to human rights and civil rights? The third important of the paper, he writes about lacking or other type of commitment to civil liberties. Now, I think that democracy can and should be defined, at least for the purposes of the paper. And I think its clear definition will allow us a better inkling as to the aims of the paper, what the paper means by diagnosing the problem as it does, as well as a better assessment of its recommendations for reform. For instance, why is a strong executive branch of government the only way to protect democratic principles? What is undemocratic or illegitimate with the drafting processes of previous constitutions in 1961 and 1982, which according to the paper received wide support in the paper is between the bureaucratic elites and the military. The historical analysis of the paper at times sees them as one and the same. But are they? Are these social groups created in Turkey? Have they remained static? But mostly the issue here is analytic. If the problem is an imbalance between state elites such as bureaucrats, high military officers, and academics versus the nation, as Professor OZTURK writes in the beginning of his paper, then why are the recommendations and most of the paper focused on civil government and military relations? It seems to me that Professor OZTURK has a larger point here. Instead of civil government and military relations. Indeed, because of a few points, the issue is rather the capture of the state apparatus by elites to the exclusion of the popular element, which he calls the nation or the people. Now, anyone who has studied non-democratic, which I did in my studies, knows how ubiquitous this dynamic has been prior to the advent of democracy. Its ubiquitous character does not mean that it has been exactly the same everywhere. The relations of the political elite and the masses are, of course, very different in modern France, for instance, and medieval France, which I studied, as they are different in Turkey today and in the Ottoman Empire. What I mean to say is that professors could, I think, do more to conceptualize and analyze this dynamic of elite capture of the state in Turkey and the relations between the political elite and the masses, that the whole society was silenced after each military coup. Its civil society unquestionably exerts some pressure on the Turkish political system, as can be readily seen in the events of the last few days. So how does this pressure work? Jürgen Habermas, for instance, explains that sometimes civil society influences political society through what he calls a crisis context, which mobilizes the public sphere, helping a public have political influence on institutionalized opinion and will formation. How does this type of process, described by Habermas as occurring in a liberal democratic society, differ from what occurs in Turkey today? Should political processes in Turkey, under threat of military coups, be described more along Habermas' description of the non-liberal political sphere, public sphere, in which the affirmation of constitution serves for the elites as, and I quote, a forum for legitimation, in the terms of Habermas. In other words, I think more conceptual work on the particulars of this process will help you better understand Turkey's public sphere. Turkey is saying that the state suppresses the nation is not enough. What do the terms nation and its single party ideology and the ultimate authority of the military fit together? How does the class struggle analysis quoted from Cleopatra for the coup of 1960 fit with the suppression of civil rights by the Democratic Party in the period leading up to the coup of 1960? This issue leads me to a more. At times it seems that Professor Cook sees current elite suppression of the populace as continuous, and I quote, a chronic problem beginning in the 17th century Ottoman era. At other times, he sees it as something modern, beginning, for instance, with the 1908 military involvement. Besides the need for consistency, I think a more nuanced analysis of the dynamics of these processes are called for. The dynamics of political control in the Ottoman Empire, described famously by Jean Baudin as the classic tyrannical rule, are not necessarily what occurred in Turkey in the 1920s, for instance. The shift of the constitutional movements of the late Ottoman period into a democratic form in the 1920s, which Professor Cook describes, could be more clearly analyzed. Was Turkey of the 20th century a republic in the classical sense? One should not confuse monarchy or the autocracy of Atatürk with tyrannical forms of government, I think. Even if Turkey was controlled by a single party, should we describe it as a tyranny? Was constitutionally unimportant in that time? We were, but addressing these questions, I think, would be helpful. My last point is comparative. I think that paper would greatly benefit from some comparative analysis. First, in terms of the constitution drafting processes. The elitist process of constitution drafting. The elitist process leads him to call the Constitution of 1982, for instance, as illegitimate, especially in light of the fact that constitutions are often drafted through revolutions. The elite bureaucracies in other instances of constitution drafting outside of Turkey exert similar influences. I think such comparative analysis would be fruitful and relatively easy to do. Especially, for instance, through Jennifer Widener's Constitution Writing website. To argue more convincingly on the legitimacy or lack thereof of drafting processes of Paris constitutions. In this context, the most important comparative question that I would suggest to ask is this. The Constitution of 1876 was framed by an elite group of bureaucrats, a process that continues to this day with all of the rest of Turkey's constitutions. Was the 1976 Constitution, or rather its drafting process, so unique in its period? Were Western Europe's constitutions drafted in similar processes? If so, and if such drafting processes changed in Western Europe, which remains a question, then why did Turkey's drafting process remain the same? And finally, I think comparative analysis might also prove crucial to other places in which the military exerted of the constitution, or comparisons to other places in which single-party rule was the norm. How does the Turkish military role in politics compare with the Pakistani one, for instance? How does Turkey's single-party system of politics in its early period compare with India's Congress party or with Israel's multi-party, also in distance? To conclude, I believe that treatment of these theoretical and comparative issues might be useful and could improve what is already, I think, a very timely and interesting paper.
Thank you very much, Guy, for these comments. How can we hear?
I think FATIH can also speak with us.
Yeah.
Hi, FATIH.
Yeah.
So, FATIH, would you like to? We can all hear you. So, would you like to respond or say something or guide us how to conduct the future discussion?
Yeah. Yeah. Do you hear me? Do you hear me?
Yes, we can hear you.
Okay. If you can, I would like to make a few comments before I am going to explain what's going on here. Actually, what I sent you paper, I did not have much time to put it on it. You know, the last 10 years, which is totally regarding today. What today nowadays what happened in Turkey. But before that, I believe that still what I wrote down in 2005 at Queen's University in Canada is still is effective. I believe that my analysis. And then I agree with Guy LURIE because, at that time it was my master thesis, honestly. And then I did not know Ron Hirsch, actually from University of Toronto. But I put on his analysis, especially about, allies and bourgeois and making constitution via bourgeois instead of taking direct democracy, making joint to public into process of making constitution. And also, I would like to come to today and then what happened in Turkey. It was great experience. Unfortunately, I was here, but it was great experience. I was with people. I saw everything clearly. And then also, what happened, thanks to Turkish National Security Intelligence Service, thanks to them. At 4 p.m., I would like to give you chronology what happened here. You want to hear it or just I would like to go to it? I think it's going to be better what happened here. My friends, at 4 p.m., Turkish Intelligence Service began to take them to, to down those military coup d'etat attempters. Then they informed president and the other ones. And then at 9 p.m., military coup d'etat attempters saw that. Normally they were going to handle it at 3 a.m. And then they saw that the police and military, actually security intelligence services taking them. Then they began earlier, not 3 a.m. because at 3 a.m. people were sleeping, It was so easy to take down the government, everything. And then there was a actually negotiation between commanding officer and then the other ones. The bridge were closed. And then first security commander officer of the army, actually, now I believe that he's becoming military commander officer, general full staff. He said, I have soldiers, they are waiting. He was not moving them. Because that time he was making negotiation with the president to become a full general staff, the army's main man, first man. And because he had a soldiers, 20,000 next to bridge, just only 2 kilometers. He didn't move until 6:30 a.m. in the morning. They said, let's move. Then also they saw the public, attack, and then they were attacking soldiers. They were stopping tanks, the other ones. Also, I was in the streets to help them, just to, with my people. Then still there was a second attempt. It was coming from eastern side of Turkey, second military commander officer. Also, people stopped them. They covered, they put the all trucks front of some military army entrance. And still people are waiting. And everywhere is a private, actually SWAT police officers are still protecting TV channels, other places, also internet providers. And then now the military, actually, sorry about that, MIT, which is not American MIT, Turkish Secret Service, and some officers now are taking down Gulen followers. Actually, clearly I can say that I was with them 20 years. I know those people from 1982 to 2003. How they work, how they tell lies, how they hide the truth, what was their aim. The issue is here from the Western world. They think issue is here Tayyip Erdogan. No. For public, issue is not Tayyip Erdogan. Issue is taking down elected governments. And then in 2005, let's go back, I recommended that effective government. Still, I am there. We need effective government and professional military. And we have too many soldiers, about 750,000, among the world top 10 military we have. And we don't need that, honestly. We need technology, more technology, and effective military. The military service should be like in Turkey, professional service. It shouldn't be that way. Also, required military service soon is going to be, withdraw. I believe that's because that's the way. Otherwise, age 20 years, any of the young man goes to military, they take them under psychological treatment for a year, which is a pain in neck for any Turkish person, young man, young boys, let me put it that way. And what's going to happen now, hopefully, is not going to be like a McCarthyism. We have to separate who involved, who were not involved. And many Gulen followers now, they began to play with the perception. Also, actually, they arrange private helicopters, second and third waves, to handle the military coup d'etat just in case. And then Turkish Secret Service, police, and then also military now, they announced that if we see anything as the air, we're gonna take it down. Then that means they cannot even use private helicopters for second or third wave. Now it seems everything under control by the government. Actually, what I am telling people, you were withdrawing Tayyip Erdogan from the government, thanks to God. You put him until forever he dies. Thanks to you, you destroyed political opposition via that way. You were taking him down, but you made him much powerful. Thanks to you, like an irony, I was telling them honestly. They helped to his powerful position, more and more powerful position he got now. Also, public now, he sees him like a real commander officers, like a army's main commanding officer is Tayyip Erdogan. If you have a question, I can go ahead, but my also recommendation that we have to establish, like Guy said on my, criticism, I agree with him 100%, more than that, representative democracy, direct democracy, public participation in constitution making. Last 10 years, actually last 5 years especially, I was advising to my students and anyone from the government side, please make public participation in constitution making, even in law making. That's the way. If you wanna be with your people, if you wanna share their values, and elitism is gone. And what I see actually, two very important things happen in this land, in Turkey, actually from Ottoman time. First one, 1908. People began to elect who governs them. Second one began about 2000. Social media network. That's the way they couldn't handle it. After that, there is no way to make a military coup d'etat in Turkey, thanks to social media network. And it seems very hard. Even Robert Fisk says that wait another one, second, third one, within 2 years or after years. I don't think so. If you want to work with Turkey after that point, or if you want to get the government or want to have a power in Turkey in politics, that's the only way. Depend on people. And everybody saw that Turkey is not like one of the Arabic countries, even not one of the Western world countries, because last 40 years we gave public, including academia, everyone, including Gulen followers, no military power. Real power is going with people, not military. Then what you say? You did opposite way. That's why none of the public believes anymore Gulen or the other kind of group or cliques. And after that, we have to make a more healthy Turkish democracy, professional army, and direct democracy, referendum especially, and also main powerful position, political positions or army position, whatever you name it, is an allied bureaucratic position, should be appointed by political figures, not anymore with the military. And I believe that is coming very new, serious constitutional development in Turkey. And with that coup, again, they made Tayyip Erdogan much more powerful. That's the way I am saying that. If you have any questions, I can have it. I think Mika's voice is coming much more clear than you. If you can give your questions to her, I can hear more clearly. Please, I'm waiting your questions, if you have.
Yeah, can you hear me?
Yeah, let's say 60–70% clear.
That's good enough for us. I have one general comment, which is for all the participants. FATIH's paper is very much related to Andreas' paper on authoritarian constitution making, perhaps even the opposite. Related to TILMANN's paper on militaries as actors in constitutional change. And all these three are related to Manar's paper on constitution making and the involvement of the people. So what I would ask all participants, when you implement the concept and when you revise your papers, please refer to each other's papers so that we could have a good dialogue, academic dialogue between us. And this would also be very useful when we submit it to the publisher, because we can show that there are certain themes that are related to all the papers. So, comment. I mean, how does this idea correspond with Andreas' idea that sometimes authoritarian constitution making could be good for establishing democracy? And this relates to Ozan Varol's other project of the military as protector of democracy, or the idea of the democratic coup d'etat. How does these ideas are reflected in what's going on now in Turkey? Also, when we talk about the military as actor in a constitutional change, as we see now in Turkey, we cannot speak of the military, because within the military we have different people pushing to different directions. So how does this influence your understanding of the military within constitutional transformations?
I wanted to ask you the role of the judiciary. When you talk about political elites, you talk about the military, you talk about the people, you didn't really address the courts and the judges. One of the first actions that Erdogan had taken following the coup is suspension or even prosecution of about 2,500 judges and prosecutors. How can you explain this? And do you think that if Turkey had real independence and qualitative judiciary being a little bit different? Andreas.
Can you hear me? I'm quite close.
I heard a little bit. Yeah, maybe it's better to. Would you be able to rephrase the question again? Just I heard judges, then sort of something like that. Honestly, like
I think you can hear it better. The question was.
Yeah.
Oh, Eli, you coming? The question, very briefly, not to do full justice to the question, was you've talked about the military, the people, the president, but there's lists in courts, and so where are the courts in the story that you're telling in the paper? And this is a question from Eli Salzberger.
Thank you so much. Actually, I am going to.
Wait 1 second, Fatih. We will collect some questions for you, if that's okay.
It's not really.
He's off. Right? Fatih, are you with us? Yes. He went offline.
Okay.
And I think Ricardo is with us.
But anyway, we're recording this, so we can just, anyway, I think we should continue the discussion and you can watch it afterwards.
Is it recorded or?
It's recorded.
Okay. Okay, then I give that comment for the records. We've been discussing Carl Schmitt quite a lot in the last 2 days. And here's, to my mind, also a very important Schmittian question at play, which is the Hüter der Verfassung, the protector of the Constitution. And I think in different constitutional situations, you have different protectors of the Constitution, which is normal situations might be the president, might be the Constitutional Court in cases of emergency too, at least ex post. But in cases of emergency, cases of exception, when we take this distinction it might be the military too, the protector of the Constitution. For instance, we've been discussing this at dinner last night, and the breaks also yesterday. When you take a closer look at the developments in European countries currently, with right-wing populist parties rising up, maybe even to the presidency of Austria or France in the next 1 or 2 years. Well, will those presidents still be in the position to be protectors of the Constitution, which was a great dilemma of the Weimar Republic too? We had a pro-president in the first half of the Weimar Republic, and we had an anti-republican president in the second. So he was a failure as a protector of the Constitution. And well, there are certain situations when democracies, in the light of right-wing or left-wing populist elections. Okay.
Yeah,
we see you.
Okay. When the constitutional order is threatened by democracy, and then in those situations, the military can be a savior of the constitutional order. For instance, I'd expect in Germany, if we had some right-wing majority which threatens democracy and rule of law, I expect in real cases of exception, political exception, the military should take measures to save the constitutional order. And this is the question whether we are observing that in the Turkish case the last couple of days, because both sides, Erdogan and the military, both claimed to be saviors of the constitutional order and the rule of law and of democracy. And so it's highly disputed, and it's a highly political and politicized question which arises with it. And the question is, given the results of the failed coup d'etat, who actually in Turkey is now the protector of the constitution? Who is it? I mean, who can save that constitutional order?
Thank you, Andreas. And I will just refer you to the recent book by Lawrence Dink on Constitution, the debate between Kelsen and Schmidt, which has a new translation of many of these debates. Tilman, please.
Hello, Fatih. I'm close to the computer. I hope you can hear me. Hello, I can even see you. That's great.
I can answer the last three questions because I hear it.
Can I ask a short one?
Last three questions.
It's a short one.
Yeah.
One more, Fatih, and then you can end.
Go ahead.
Go ahead. Just a second. It's a simple question. It's a simple question that I have. What was the change in the military leadership in the last, let's say, 10 years or so? There was the change in 2011 of the Supreme Command, and before that, of course, there had been these Ergenekon trials. Now, in past coup attempts or coups, the military leadership, the highest ranks were involved. Here it seems to be different. And the majority of the leadership seemed to defend the government in that situation. What has changed? Are there now more loyalists of the government and of the AKP in the military leadership, or what is different now?
Thank you.
Okay. I would like to answer three questions. First one is judiciary. Second one, if the public trusts democracy, I think. Third one is what happened with some military leadership. Is that okay? Is that okay?
Yes, thank you.
Yeah.
Yes.
First one is judicial independence, judiciary. Earlier I said that I was with them. I know how they recruit people, how they raise them. Is all actually now I'm very specialized in that field, Gülen and their followers, honestly. Because last 30 years, Gülen mainly put his efforts into military and academia and judiciary. He was very successful. Actually, I have to add that what happens in Turkey anytime, public always thinks one is USA, second one is Israel. What their involvement? In that case, interestingly, first time, people 100%, including government, believes that US clearly involved and Israel is natural. They didn't involve anything that time. Thus, I believe that good improvement. And judiciary was actually under control of judiciary is actually under control of Gülen followers. That's very clear. Everybody knew that, including public, state, everybody. That's why those people who were involving that, they were with the soldiers, military coup d'etat attempters. They were together. Second question is, if something is happening like Germany, thanks to the guy question, actually same question came to me in 2005 when I was defending my thesis in Canada, Queen's University. My supervisor was Sivi Kahana from Israel originally, from University of Toronto. His PhD, thanks to him, he said, on behalf of me, Fatih believes in nation. Turkish nation never ever involved this kind of things. always they show respect to, you know, minorities. Is not gonna happen in this time. Also, I added that Turkey is not gonna never ever be like Iran. In our Sunni belief, we never believe mullahs. We believe individualism. Yes, we respect the religious leaders, but not like they're our gods. We have to follow, you know, Quran or Prophet, Messenger Muhammad's things, you know, not mullahs. But the meaning was Gülen was taking Turkey something like that. From outside, sort of Islamic state. Inside, it was his followers' controlled state. And trust me, now they see me like a traitor, Gülen's groups, because I know everything, I can analyze that. Third question is the last question was, I would like to remember that. What was that? Last question.
The question was from
Yes,
Tilman.
I remember.
About the changes to the military.
With Ergenekon and Balyoz, you know, Hammer case. You know, one of my specialty areas is minority of Turkey. With Ergenekon and Balyoz, I call it with my own words in my lecturing time to students. They take away Selanikko children from the power. I think you understand what I am saying. I don't want to go more in it. And then they put it there, Eastern children. You understand what I am saying? But with Ergenekon and Hammer case, in Turkish name is Balyoz, they take down Sabatay Sevi's children from the power. Then they put it there, Eastern children. I think that's very clear. That's why they were fighting each other under the table for military power. And the last things, actually, also they involve military coup d'etat. Some of them, not all of them. It was like almost all allied groups was against Erdogan. They were taking him down when at 10 p.m. first officer of the first military commanding officer guy said, I am with president. Then they realized that they are not going to handle the coup d'etat. They lost. Then they began day one day and per hour, okay, we are next to democracy, including American embassy in Turkey. First hours, they announced from their webpage, Turkish Spring is coming. Dear American citizens, don't go around in the streets, stay your places. Then after 3 hours, they realized that they took out from their webpage this announcement, and then they said, we are with elected governments. And now everybody knows that. They made, it was a shameful things, and especially Western media, Fox News, still they say we lost. It was our last hope. And I advise those Western friends, please believe in Turkish nation. Be honest. Don't worry. Turkey is never ever is gonna be like Iran. No way. Believe it, and then work together with the nation values. Leave allies of Turkey is not gonna be, you know, give long and healthy relationship with Turkey. And I believe that constitutional developments now is coming as the age, because there is no way to escape from that. Even Erdogan, if even he doesn't want to have direct democracy, he has to have, because public now, they would like to have a life standard like, for example, Britain, Canada, USA, even Israel. People say Israel have this kind of life standard. Why we don't have it in Turkey? We are so rich nation. And people are questioning, challenging that. And personally, hopefully, if you invite me to Haifa Minerva Center after this is gone, I can come and let you know face to face what the military, real roles, figures who handled this coup d'etat. Thank you so much, guys. Any questions? I am alive here and I'm in the middle of the coup d'etat attempt. It was honestly fantastic experience, unbelievable. What I was writing my thesis, I saw them with my own eyes, and I live it. It's amazing. It was very dangerous. I was at the wanted list. They informed me that it was successful. Now I was in the prison, and they are going to torture me. Trust me. And thanks God, didn't happen. Any questions?
Well, you're okay. I think we will all send you comments and questions via email, and I already sent you guys.
Yeah, I got.
So you can.
Very helpful. I was going to use, actually, I can say that Ron Hirsch books. It's very theoretical. Also, Hannah Lerner. I'm reading that. Those kind of things and theoretical aspects was very helpful, but just one point make it. Actually, it was 2005, this paper. I'm going to, reshape, and it was, again, a great experience living military coup d'etat. And thanks to you guys. Hopefully see you over there.
Fatih, thank you very much. I don't think you can hear Yaniv too well, so I'm going to just thank you on behalf of the group. Thank you to Guy as well for the comments. And we're going to continue now with the second paper of the panel. You're welcome, obviously, to stay and listen. And thank you again very, very much.
Thank you so much. Thank you. Thank you.
He left us.
Richard, if I can just say something. Correction, I said earlier that we speak with Ricardo.
Oh, he's here.
Through Skype, and that is incorrect. This is Google Hangout. Just credit issues to be on the safe side. So, do we have Ricardo?
Ricardo, is this with us? Ricardo, can you hear us?
Yes.
We cannot hear you. Okay. Hi. Ricardo?
Ricardo, can you hear us?
Ricardo?
Well, he is there, but he cannot hear us. Ricardo, can you hear us? Well, maybe Yaniv, in the interest of time, you want to...
Okay, so I will start. If Ricardo would like to intervene...
Oh, it looks like he's here.
Yeah.
Ricardo, can you hear us? Ricardo, we can see you, Ricardo, but we cannot hear you.
No,
we cannot hear you. We can see you.
Maybe you should...
We can see you, we cannot hear you.
Turn your audio on or make it louder.
Now? Maybe say something? We can still see you, but we can't hear you.
Now you're muted, now you're unmuted. Can you hear us? You can nod and...
Yes.
Yeah, he can hear us.
Yes, Ricardo can hear us.
But we cannot hear you for some reason. No. Now it should work.
Now the photo is frozen. Well, maybe Ricardo, if you can hear us, we're maybe going to start. You've very generously sent us your comments, and if you get the audio, we will come back to you. But for now, I think we should get started. So,
okay, so I will just briefly. Ricardo sent me his comments. So now we're moving to TILMANN's paper on the role of militaries or military actors in constitutional change. I will briefly read Ricardo's comments, and if he would later will be able to elaborate, that would be perfect. So here it is, full quotation. Dear all, I wish to thank the organization for entrusting me with the responsibility of discussing the present paper. Unfortunately, unable to personally take part in this very interesting conference and panel precisely as a proof of the current interests of this matter. It was the recent military intervention in Turkey that cancelled my flights and made it impossible for me to join you all in Haifa. Most military interventions throughout the world have led to authoritative regimes and in some cases to long dictatorships. The pessimistic outlook when dealing with this matter is therefore understandable. Presently, difficult processes of democratization take place not only in Egypt, but in Myanmar, Thailand, and still in the Solomon Islands, and elsewhere in the world. The power of the arm is still very much felt in modern societies, even democratic ones, as Eisenhower altered to the weight of the military-industrial complex. Not all cases are negative, however. I come from a country where the democratic transition was prompted by a military coup. On 25th of April 1974, after 48 years of dictatorship and more than a decade of a disastrous colonial war, the military coup initiated the transition to a modern democratic regime under the rule of law. The militaries withdrew to the barracks and let the political process take place. The first elected president was a former military man. The process was not always easy. At one point, the military exercised full power of the country, even judicial control of the constitutionality of laws. However, the constitutional amendment of 1982 allowed for a transition that culminated with the membership of the EU in 1986. This is Portugal. I'm currently working at a place where the weight of the military is also very much the case I was presenting. In Timor-Leste, the weight of the military is the heritage of the 24 years of military front of the struggle for national liberation, together with the diplomatic and clandestine fronts, against the violent occupation of Indonesia. During the transition to independence and democracy, the presence of the UN pressured the new country to abdicate its armed forces, which it refused. In 2006, the crisis between the armed and the police forces prompted a new UN mission. The reasons are, however, deeper than the apparent obvious clash between the two branches with a monopoly for the use of force. In 2008, this crisis gave rise to a complex system of governance that was enshrined into the law in 2010, a system of national security under which the military and police can be used in domestic situations prior to the state of emergency. From a legal perspective, the intervention of the military is under the rule of law, civilian oversight, in brackets, even in cases of the constitutional suspension, state of emergency. Out of these cases, we come into what my presentation called the Big Bang of Constitutionalism. Now, it is no longer a legal matter, but still a political and constitutional matter, like Professor Rohrer enlightened us in the beginning of his presentation. And always a military coup, and also a military coup, is always illegal against the order it aims to topple, and it is legitimized by the legal orders that it aims to implement. The idea of justice, said a Portuguese scholar when analyzing of the democratic transition, Miguel Galvão.
Sei que eu estou aqui a falar ao telefone, estou a falar no computador, está bem?
Oh, Ricardo,
Ricardo?
we hear you.
Leonor, estou aqui ocupado.
Ricardo, we can hear you.
Yeah, can you hear me now?
Hear you now.
Yeah, I got the
Hear you
earphone.
now. We can hear you now.
Okay.
Do you want to
I have two sentences and then I finish Ricardo's talk, and maybe he can elaborate if I missed something. So Ricardo is referring to the idea of justice, that the actors, the coup d'etat accomplishes justice. Schmidt would add also by success. And this is the question that Ricardo poses to Tilman. If any, there is a question I would raise to Professor Roeder, which is probably too early to answer. After the very thorough description of the military's role in Egypt, between the legitimation by the idealist justice and realist success, how does one legitimize the intervention of the military in Egypt?
Yeah. If I can elaborate on that, that was a question that was posed to by constitutional scholars in Portugal, especially after the coup of 1974. Of course, that that particular scholar, Professor Galvão Teles, unfortunately already deceased, he used to state that it is a coup if a legal order has the right to defend itself. If any legal order has abstractly the right to defend itself, a coup is always an attempt against an established legal order. And in that sense, it's for the new legal order to legitimize itself with an idea of justice. This is, of course, a constructive perspective, and that was also a demand to the authors of the coup, so that they did not forget the idea of justice behind the coup, so that it's just not simple change of power. In the Portuguese case, it was, if I can just go back to that description, it was already, of course, it's a different reality. It was more than 40 years ago, but that was very much the case. There was always present that this was a democratic transition. And even though in the early years there were some excesses, especially because we were coming out of a right-wing inspired dictatorship, and some of the excesses were, if I can say, left-wing inspired also. The idea of a democratic transition was always there. There is also a professor from my professor that used to say that there was a dualistic transition. On the one hand, we still have in Portugal a very social constitution, where the social rights, economic social rights, are very much present in the constitution, even though they are hard to implement daily by the administration and by the judicial. There was a social transition, but that was always present to be a democratic one, and that was the end result. The idea that you have to legitimize the coup with an idea of justice. In this case, the idea of justice was, on the one hand, social rights, on the other hand, democracy. Nowadays, we come to a different reality. And of course, that there always is a question of power, of changing of power. But nowadays, it's very hard for me from the outside, and I think for everybody, to try to explain what is the idea of justice behind some of the coups in the military coups in Egypt, now in Turkey, even for us to understand the phenomenon of the so-called Arab Spring, because we see it with one perspective, with a foreign and European-based or Western-based idea, which is probably the one that I described, towards democratic regimes, towards human rights, and that is probably not the case for someone that is on the inside and that understands the political process behind that. And so for me, that was more a question, a commentary from a foreign outlook than actually it's something that I don't have an answer for. Because as we look into these processes, it's really difficult. I am currently working. I'm now in Portugal, but I'm currently working in Timor-Leste, and in Timor-Leste also, the military intervention for 24 years, and now it has been always oriented, or always goal-oriented, and that was the independence. Timor-Leste is a very small country in Southeast Asia. I don't know if all of you have heard of it. It was a Portuguese colony, and in '75, when there was a revolution in Portugal, it was annexed, occupied by Indonesia, and for 24 years there was a very violent occupation. So the military always had that goal-oriented intervention towards independence. Nowadays that independence has been achieved, it's difficult to change that mentality towards democratic rule, towards civilian oversight, and that has been a process which had some consequences. In 2006, there was a crisis that was somewhat managed, if you can manage a crisis, until 2008, and only in 2010 there was a law, the national security law, that clearly brought them into the under civil oversight. And this process has been in Timor-Leste much more difficult than it was in Portugal. In Portugal, the military themselves went back into the barracks and let the politicians do the political work. In Timor-Leste, many of the political actors are still former military. For instance, my boss, the now president of the Republic. And so here we see also the difficulty of having, what is the final goal? What is the idea behind this intervention? As I said, in Portugal, we had this idea of justice. A new legal order in a coup has to legitimize itself according to some values. In Portugal, they were social justice and democracy. In Timor-Leste, they were independence. Now it's more difficult to see how you can encompass military intervention with economic development. It's much more difficult. In the new interventions, especially Egypt, which was the one addressed in the paper I was commenting, but also Turkey, and even if you think broadly, from a foreign perspective, I have some difficulty understanding if there is or what is this idea of justice, of value, of material legitimation that we are achieving. So that was my contribution to the discussion, mostly. Thank you.
Ricardo, thank you very much. By the way, I'm Richard. The voice you heard before was Yaniv.
Yeah.
And here is the group.
I've been following you. I know you all. I've been hearing you.
Wonderful, wonderful. Tilman, if you have any thoughts.
Tilman, maybe you can sit here so he will hear you best.
That's great. And Tilman, just let me suggest if you have any thoughts, just please come.
Yeah.
Request for clarification so that we can get some comments for you as time is running short.
Of course. Thank you, Michael. So, hello. Thanks a lot for your comments. Can you hear me well?
Yes, fine.
Okay, great. So, nice to see you over there. Thanks for the very valuable comments and the parallels with the Portuguese and Timor-Leste examples or experiences. That was very, very interesting and enlightening. Then a bit about the background of my research, which probably will be an ongoing research over maybe several years in the future, and then come to your questions and your specific comments. And this might lead us in a further discussion. So the background of this paper is a research where I compared the 5 republics that were involved in the Arab Spring developments, Tunisia, Libya, Yemen, and Egypt. And in all of them, the role of the military was different. That was something I found very interesting when I worked in the region in 2011 and 2012. And the military was a factor that was there, but from a law jurisdiction, it was never perceived as an actor in the constitutional sphere, though it actually was, through its power, but also through direct interventions in constitutional processes. So that's where my interest comes from. And then, of course, when you look more broadly, but also in ongoing developments, you find many examples where this is the case. So this is, by the way, one of my questions to the group here. If you know on working or having written in this field, there has been a strong interest in Israel in the 1960s, 70s. Political scientists, also jurists writing about the military from comparative perspectives. But in the 80s, 90s, 2000s, generally in the world, there's much less written about these matters. I will not go into detail of the different Arab republics now. My aim is to actually understand the military as an actor, on the one hand, in constitutional change processes with different directions it can take, as you have perfectly shown with the example of Portugal, which can be an actor that brings the country towards democratization, but also in the other direction, which is the case of Egypt, rather. And on the other thing is, what is the legal framework of the military? I have limited here to constitutional law, but one would have to go beyond in a thorough analysis. You would have to look at provisions of international law and sub-constitutional military law, which makes things difficult. You know, when you research on a country like Egypt, my knowledge of Arabic is limited, so I wouldn't be able to read all the laws. So that's the natural limitations that we have. Also, at the outset, what I'm very interested in, my paper is rather descriptive still, and I want to go more into deeper analysis. So hints in regard of improvement of methodology, but also theory that I could study and apply here would be very beneficial. So that's also something I would ask this group maybe to help me with now or in the future. I am coming briefly to your comments on legitimacy, and well, I don't think that, I mean, all military coups, or most of them as far as I can see, try to legitimize themselves. The new military leaderships that take over try to have some reasons and explain why they are legitimate. And that can be religious, or it's about stability, it's about international obligations that have to be protected. It's about principles of the states that have to be protected, like in the case of the previous coups in Turkey, where it was often about like Kemalist principles to be protected, and so forth. In Egypt, that was also the case to some extent. The military argued, first of all, we have the people behind us, because in 2013, when they took over the power, there had been demonstrations and millions had been on the street protesting the government of Morsi. But why? Why did they protest? Well, the economic situation was getting worse and worse and worse. There were power cuts. There were problems with, missing the English term, proper basis of living, improving the base of living of the people. And it's not proven, but there are theories in Egypt that the military was to some extent behind that, which is not so surprising because the military is the largest employer, the largest economic factor in the country. And of course, they can have an influence on the economic situation in the country. And kind of as the people implement them. The other aspect about the kind of this argument, the people's behind it is well, one would have to look a bit further back. In 2011, the core demand of the Arab Spring was a so-called Dawla al-Madaniyya, civil state. And the civil state was broadly understood as a state that is not controlled by the military nor by a theocracy. So it doesn't have to be a Western model democracy. It doesn't have to be secular, but not controlled by such elites, military or theocracy. And then in 2013, the military, arguing the people behind us, brings the kind of state that is completely controlled by the military. So that is a doubtful argument, of course. The other argument was at the time the threat of Islamist rule in Egypt, and then they changed the constitution again, but they didn't change much of the relevant provisions. So in my view, the main reasons behind that coup were, first of all, an enormous sense of frustration. There had been 1 year of rule of a president who provoked this military several times, who was the first leader of the country, first president who was not from the military ranks, and who tried step by step to bring the military under civilian control. It would be interesting to compare now with Turkey, and that was one of my questions to the author of the previous paper, FATIH, OZTURK, to see how this actually happened in Turkey, how the government of Erdogan was able, I think probably around 2010-11, to change this, this hierarchy between them. A further argument has been international obligations. So the military said to broadly and to those regional countries they have contracts or the country has agreements with, we will ensure that no war will kind of come from this country. We will ensure stability. And I have the impression, even though in many countries was, this is a coup, this is not acceptable, it's not democratic, that nevertheless many governments were like, okay, that's better than what we had before, the actually democratically elected President Morsi. And the US military aid of 1.3 billion years. So the justifications the military brought in the case of this coup of 2013 are, in my view, very doubtful, but there were attempts to convince the public. Altogether, we have a situation that is very similar to before 2011. We have a military elite that has the economic and political power firmly in their hands. A military former general who left the office for a few months and then was elected. Now there, before the name was Mubarak, but the situation is very similar. Only the power of the military is stronger than before. So these are my few comments, and thanks again for very insightful and good views. I'm actually trying first to have a more comparative and better paper for this, the book that stands here. But then in the future, I'm also thinking about a larger research project, and you can be sure that I will contact you in this regard, Ricardo.
Thank you. Tilman, thank you very much. We have a number of comments and questions, so let's table. Andreas.
Yes, thank you very much for the paper and the comment, which I found very enlightening in the light of my own paper. And I have the first question to you, Timmann. You sketched out those various elements of the justification the military gave for the coup. And I'm missing one. I might be mistaken, so correct me if I am mistaken, which they also laid down, which was presenting themselves as the savior of the revolution. In the sense of, as you mentioned, the major aim of the civilian state and not a theocracy, and that then the military during the coup d'etat presented themselves as the actor who saved the revolution, Muslim Brotherhood, which they suspected to install a theocracy. So was that during that phase an argument the military made? I remember at least in the Western public it was regarded a bit like that, because you had voices which said, okay, let's wait, maybe the military will save the revolution and prevent Egypt to turn into a theocracy. And the second thing I'd like to say is, which also is in connection with what we did in this section, when you compare those different situations of constitutional change, Portugal and Egypt, and the role the military plays in those two contexts, we come to those things which are about the constitutional mindset. The question is whether or not the military as an actor in constitutional change has this sort of constitutional mindset to play that role as a savior, as a guardians of the revolution, the guardians of the forthcoming or newly implemented constitution. And if they don't, if they are rather led by economic and political interests of their own, they become a sort of an usurper of the revolution. From a normative theory, normative political theory perspective, the major issue at stake in these questions.
I would add, just in addition to the constitutional mindset, what is the tradition in which that country is rooted? Is it a revolutionary tradition? Is it something else that will have an impact? Milan?
Thank you. I think that I have two comments. One, I think that we should distinguish between legitimacy and justice. I think that legitimacy is a descriptive sociological observation of whom people feel consent or are not revolting enough, tolerating. When we look in the society and we ask if there is a legitimacy, it's not a subjective, an objective perspective from moral, that if it is justified or not justified. When we ask if in Turkey or in other places there is a legitimacy to the current regime, is there a legitimacy to those that revolt against it, we ask how people feel about it, even if it's not a justified feeling in our perspective. So we are interested, I think, in both, to know whether there is a legitimacy thing among the people that can influence the reality of the society. The second point is that indeed power, if we return to the paper of Cunha yesterday and to Schmidt, the issue of sovereignty as power and power as in need of legitimacy. Power is not only legitimacy, but when we ask, okay, what will do the soldiers? What will do those that can put in? We are asking about their interests, and their interests includes values, not only values, but also values. And so the decision, if they will put the trigger, is depend on this overall interest that they might have, including their values. And what I think, and of course not sure at all, but that the change in Turkey is connected to the change in the legitimation and the legitimation of the civil regime in Turkey, and the arguments within the army are connected to those different views about is there a legitimacy to the current regime, or is there a those that want to revolt against it? So I would not look only at the elites or the top brigadiers or generals. I will ask about the people that care and those that can risk their life and stand in front of the tanks, and I will connect it to this issue of legitimacy.
Thank you, Ilan. Yaniv, when you get the microphone.
Yes, thank you. I'll just add to that. I would actually go to Richard Fallon's paper on the concern of legitimacy, because he makes the distinction between different types of it. We have social legitimacy or legal legitimacy or moral legitimacy. So perhaps make use of this distinction. As for the paper, I have two questions and one proposal. You mentioned someplace that the militaries was written to be active against citizens. And I just wonder, can we make distinctions between militaries where there is a compulsory risk or not? Because the way that the citizens feel connected to the military, willing to trust the military, or the manner that the military is willing to act against the citizen, might also depend the military's compulsory services. No, because then you fight against your own, brothers and sisters, everyone's in the military, etc. So there might be a distinction here. I don't know, worth looking. Second thing, you mentioned that military courts facilitated the arbitrary declaration of state of emergency at page 14, and I just wasn't sure what it means. And this might be an issue that's worth elaborating. How these actions cause arbitrary declaration of emergency. I just wasn't sure about that. And so we're all focusing on the role of the military before and during the constitutional change, right? The coup d'etat, okay, the generals are now taking the power, but I'm just wondering, maybe it would be interesting to elaborate upon the role of the courts in the post-revolutionary or coup d'etat or transformation when drafting the constitution. Because Johan Elster has this famous thing on constitutional drafters as self-interest actors. So it would be worth examining the constitution drafting process and how the militaries use this process to entrench their own interests and to remain in power for the future of the constitution.
Thank you, Yaniv. Pedro.
Yes, thank you for sharing this interesting paper, and further along the lines of that's been said by Andreas, Ilan, and Yaniv about legitimacy and some indications you already have in your paper, wondering whether this can be turned into an argument, but of course it might be too mature. Mention that when there was an attempt to obtain a special status for the armed forces in the new constitution, and how this grew, how this caused public annoyance in the second paragraph, at the end of the second paragraph, and then again on page 10, you mentioned how the armed forces at the end of page 10. Constitutional Council of the Armed Forces second provision that reduce its power, and the actual causes for this, as you mentioned, is not known, and you present the possibility that they might have done so in order to avoid any further public annoyance. So the public here keeps coming up, and sort of that they take into consideration before acting. And this may be related to legitimacy issues, whether it's a social, and I wouldn't go as far as saying it's a democratic legitimacy, maybe too mature again, but there's to be something here that it can either, in order to exert it much harder to do so when they have the public against them as a matter of fact, or it may be something else. This is smile is out. I'm wondering whether further arguments could be made, starting from this assumption that they care about what the public says and they portray themselves with favors and even in order to convince the people that they are legitimate. So I'm wondering whether this could be further expanded. Thank you.
Great, I'm none.
Just a brief comment on what I think hasn't been raised yet, and this is the notion of transition to democracy. Because I think the question of the role of militaries is interesting, or could be interesting from the perspective of the rule of law, not only the extent that we view it from within transitional justice theories, and the term is transitional justice, but what is meant by the term justice here is actually a move towards democracy. To the extent that a military coup happens or takes place within a dictatorship or an authoritarian regime, I think it's meaningful to say necessarily in terms of rule of law under some conditions, beyond some basic observations about the constitutional revolution that just happened because power moved or sovereignty was redefined or a new normative pyramid was created, etc. So it's just but to the extent that we view the role of militaries as something unique and challenging, it must be with respect to the relation of a move towards democracy. And here I think that the work Andreas was doing in terms of the authoritative input towards less authoritative regimes or what should be. So to the extent we have an injection of the military, which says, I'm your only, or maybe not only, but best way towards democracy, or towards a more democratic life, as may be the case in Turkey or as may be the case in other situations. I'm your bastion against illiberal forces. I have either the mindset or the values, or I understand my role in the system. So please have your trust in me. Then it becomes interesting. Then I mean that's where the trade-off, both analytically and empirically, in terms of whether it works or not, and analytically whether we can justify it or not, it becomes, I think, interesting. And to the extent that part is missing, maybe we're not necessarily having the best traction on the question at hand.
Thank you. Is it right on this point, Andreas?
Just very briefly, another case for comparative approach is Myanmar, Burma currently. I mean, where the military, which is a military dictatorship in transition, more or less transition to democracy, somehow pushed to do this by the international community and some external actors, and with a strong influence on the constitution and the constitutional change happening right now. Closer to
Myanmar.
Burma.
It's called Burma.
Thank you, Andreas. And Suha.
Yeah, just one small comment on as we discussed was the legitimizing aspect of the military taking of the authority. From what I remember, what was very something that accompanied the revolution and the Morsi administration was the lack of security of ordinary Egyptians. It started with the claims that the police during the Mubarak usually initiated some violent acts, and later there was the prison that was during the revolution was attacked, and the release and the escape of thousands of criminals that was later claimed to be blamed to be an act that was made by the Muslim Brotherhood. And during the Morsi administration, this sense of insecurity continued, and there was neither trust in the police nor in the Muslim Brotherhood to preserve or to be presented as the the institution that preserves order. So one of the legitimizing, in my opinion, one of the legitimizing Sisi administration was that we are first and foremost we are preserving order. So it was a Hobbesian legitimacy, if you can look at it in this sense, exactly because the police wasn't able to do that role. So it's interesting when we discuss military to talk also about the police as two state, two actors that have actually the ability to use power in a violent sense.
We have time for just very short comments. Very short. Ming Sung, very short, and Andreas.
No, just, I think
Microphone.
This is just a suggestion and also a kind of a honest question. Yes, I think when we talk about the role the military has played in decision or coup d'etat in general, maybe we need to be more specific. Are we talking about the citizen soldiers in countries where military service are mandatory, or are we talking about the army officers or the other? And I think if we take this distinction into account, and then we may get more of the role the military has played.
Thank you, Ming Sung. You have a lot to think about.
Yes.
A lot of comments. A provocative
And,
paper, a great paper.
0 minutes as I can see.
Yeah,
Watch,
well, let us thank you, and let us thank Ricardo as well.
Okay.
And Yaniv for reading Ricardo's comments. Okay, well, thank you to all. We're going to take a break now, but don't go too far. The food is served here, so serve yourselves. And at about 1:15, we'll reconvene for the poster sessions. Each will get about 5 minutes. Posters until there. The lunch break will be yours to walk around. Yeah.
Ricardo, maybe you want to talk first on your poster. I can try and have it.
Great.
Yeah. For me, it's cool. It's okay.
Okay, so stay with us.
So please go serve yourselves.
I'm meeting us, so I will unmute us ourselves later.
Okay.
Don't unmute yourself.
So should I talk first? Let me know when I should talk.
You will hear us. I mean, you hear us. I will unmute ourselves so you will hear us when we start. Okay?
Eternity.
Okay, we're back online.
Yeah. Now I don't know if Ricardo is going to go first.
Ricardo, I think it will be better if Ricardo will go first.
Yeah, if he's around.
I put the camera so we can see his poster.
Oh, that's great. That's great. So, guys, we think we will go with Ricardo first since he is online, and then because he might then just go. Okay.
Ricardo, are you with us? No, he's not with us.
Ricardo?
Yet. No, he's still on
No.
mute.
Maybe we can email him, or no?
I can try. I told him that we will be online, and then everybody hears us now. Right?
Okay. Yes. So if he's not ready, then we will just go with someone else. First.
Possible. Maybe start with you.
You should.
I'll tell you why, because I want everybody to
Start with
here.
who?
This is yours, right?
No.
Maya.
Maya.
Okay, so if Ricardo is not online, maybe we can start with Maya,
Okay.
and then we'll just pull the.
Oh, I see.
And so everybody will be next to the camera.
So we're going to start in about 60 seconds with Maya's presentation. If that's okay. And then we're gonna pull it away. So that's why I think we will ask. But take some time. No, of course, take some time. Take some time. Yeah. If you need a couple of minutes or whatever, that's fine. No, please.
Should I come here?
Yes, and let me move the chairs for you so you can have some space. How is that? Is that good for you?
Just to work here.
Oh.
I know how you feel.
No, but I like thinking. So for me, it's perfect.
Maybe I should have given you, because I printed small
Okay.
small pieces. Yeah, maybe. Please take one. It's too small even here. This was meant for a close look, but
Later people can walk by and
yeah, of course.
So our first poster presentation, Maya, thank you very much. Please.
Well, I'm not really prepared to do this because the format should have been different, but I'll do my best, and then you can ask me questions if I miss something, and I probably will. I just realized I missed the article here, because in my language there are no articles. So you'll forgive me for being illiterate this time. The name of the paper is Reasons Behind Asymmetrical Constitutional Arrangements in Bosnia and Herzegovina. However, Bosnia and Herzegovina for me is here just an, let's say, control case study. I rather focus on, let's say, asymmetrical constitutional arrangements. Do I have to? I feel like a pop star now.
You are.
Yeah, okay. Rockstar, yeah, but I don't qualify for any of these. So the problem is date and peace agreement in Bosnia and Herzegovina, which was signed in 1995. And in its Annex 4, which is, let's say, part of the agreement, there is a constitution, and this constitution sets up one very weak state level, two very strong entities, and of course 3 constituent or constitutive people. This term is, let's say, contested. There are differences between these two if you ask scholars in Bosnia and Herzegovina. So there are few asymmetrical arrangements that might have a potential to be accommodated, but however, even to take a look at this, I have to look at the federal theory to that sense to be able to apply any of possible solutions. So what I did, I developed, let's say, a theoretical framework for this one, but instead of, let's say, having a look. Yeah. But instead of taking a look at the traditional federal theory, I rather go towards the contemporary federal theory. The reason that I do this, and I discussed with Richard previously, is because in traditional federal theory, federal state actually asks, it demands the equality of subnational entities. I think I mentioned equality yesterday a little bit. Here, symmetry between these territorial elements is implied, while asymmetry is actually considered to be an exception. Which means that if there's more symmetry, that means more unity and more harmony. Also, in traditional federal theory, diversity, or multinationalism, as I call it in the case of Bosnia and Herzegovina, requires coercion from central level. So, in order to deal with diversity, there is more symmetrization needed, let's say, to keep everything together. But if that's the case, then my question is why federalism is needed anyway in these societies. So I rather go towards the contemporary federal theory, which is quite new when it comes to this kind of notion, which considers something that is called multi-tiered systems. They're not even called federal systems for the reason that, federal arrangement is maybe better, a better term to make it closer to you, because certain federal elements are, let's say, hidden or converted even in unitary states, like in Italy, for instance, that I referred to yesterday today. So to that extent, it is somehow suggested that it's better to call multi-tiered system, and this is a term that was introduced by Ronald Watts. Then I refer to dynamic notion of federalism, which is actually considering federalism as a process, something that is developing through the time in order to accommodate to these differences. And finally, I refer to Burgess, which says that significance of diversity is actually the quality of difference, which means that multinationalism is actually a good thing. It doesn't have to be a problem. So this is what I call multi-tiered multinational systems. So the only similar thing between these two, this allows me to work quite flexible within the scope of it, that the authority is divided between two or more levels of government, and that's pretty much everything that is, let's say, close. I don't know, are you introduced to the fact of the asymmetries, but there's a general division between de facto and de jure asymmetries. De facto is something which is based in society. These are relationships based on religious, linguistic, cultural, ethnic, or any other differences. And there are preconditions for constitutional asymmetry. Once these are incorporated in constitution, they become de jure asymmetries or constitutional asymmetries. There are certain indicators of constitutional asymmetry. For Bosnia and Herzegovina, these do not actually correspond in the sense that they all are there concurrently. But it could be related to territorial delineation. If it's, of course, constitutionally entrenched, doesn't have to be that way. Usually it's distribution of competences. I think your paper is pretty much about it, which is seen in Spain. Distribution of financial resources, or something that we call fiscal federalism, also in Spain present to some extent, in Italy, and also the problem is sometimes regarded to as the representation in the central level legislature, but this I would have few objections, because it is argued that proportional representation is actually not equality, but then it desolates the one person, one vote rule. So I have issue with that one when it comes to traditional federal theory. And of course, certain constitutional amendment procedures which requires veto voting and etc. So to that extent, I propose a theory consolidation in terms of did I connect these asymmetries to the nature of the multinational multi-tiered systems, and I connect it to identity. I connect it to multinationalism of the system, which I do not look as majority nation or minority nation, but rather the system as a whole. So what I still need to answer in order to write a conclusion for this is that asymmetry puts at risk constitutional values, which are cohesion of the system. I can explain that. I will not go into the detail right now, but if you're interested, I will. And equality. But my presumption and my initial thought is that it will be confirmed. So I'll need to look for constitutional safeguards to, let's say, elevate this. But if falsified, then I think I'll have a problem, because it will mean that it can be employed as a federal device for multinational, multi-tiered systems. So perimeters that I analyzed are basically that I identify these constitutional asymmetries, that I try to determine reasons for this, and I find them in multinationality. And I will try to answer how far can this actually, let's say, explain these constitutional asymmetries. That leads me to another question, and that is to which degree can constitutional system actually bear with the asymmetrical solutions? So how long can it take until the system breaks, or how far can it go until the system remains stable? So the conclusion actually is that the Bosnia and Herzegovina is multi-tiered system. Yes, it requires the fact, it actually supports the fact that it is a new federal system, which means that, and I think, we spoke about it in the morning, these new federal systems are actually fragmenting states. They are holding together states rather than coming together as Stepan suggests. But it's multinational state, which means that diversity in this sense is of key importance. And it leads me to the conclusion that constitutional asymmetries in Bosnia and Herzegovina, in the case that it was made as a constitution of emergency, and it is highly contested whether if it's actually enforced in Bosnia and Herzegovina, because it never went through the parliamentary procedure, for instance, translated to any of the official languages in the country. But yes, yes, they have it. And I argued that all of this is consequence of multinationality, and we talk about imposed authoritarian constitutions. I can relate to that to the extent that it is highly regarded, that it has been imposed by the international community, which wanted to end the war and then interfere to that extent. Yeah.
Ricardo, are you here with us?
Yes, I am. Yes, can you hear me?
Yeah, we hear you. We have your poster on the screen.
Yeah, Ricardo, you're there?
Yes.
Okay, great. So you have 5 minutes. We can see your poster. It's here. So go ahead, please.
Okay. Thank you very much. My poster is a presentation of the constitutional process still ongoing or permanently open in Timor-Leste. Timor-Leste, as the poster shows, is the first part attempts to locate Timor-Leste, since I am not sure that everybody is aware of where it is. It's in Southeast Asia. It's part of an island. It's only half an island. It was colonized by the Portuguese, and for over 400 years. And it was in 1975, when there was a revolution in Portugal in '74. It was invaded by Indonesia, and there was a 24-year Indonesia, which is the country right next to it. There was the recognition of that invasion only by Australia, who later signed treaty on the delimitation of the maritime borders to the South Sea that you see there, which is a oil-rich area that was explored. Internationally, the occupation was considered illegal. However, there was not real pressure, especially the United States, that accommodated easily the invasion with fears of a communist rule in Timor-Leste in the 70s. Can you come down? So
You
this
have to
is
direct.
yeah.
Say left to right, or
yeah. I'm sorry the presentation is like this. I had a physical expression of this, but then I couldn't make it there, so that was the problem. In 1975, there was a first attempt at a constitution. It was a very small. This is the example. It was a very small constitution, which consisted basically of the declaration of independence and little more. And there was invasion, etc. Can we go back? Can we go down to the present time? Okay, here right in the middle. In 1999, there was a referendum, and the referendum was the result of an international agreement between Portugal as the administrative power and Indonesia, the occupying power, and the referendum voted largely for independence. The transition was ensured by a UN mission. It was the first UN mission of the type, aimed at building, at not only peacekeeping, but almost country building. And it was later the inspiration for the mission in Iraq, with the same head, which was the Brazilian Sergio Vieira de Mello, that died in Iraq on a terrorist attempt. So from 1999 to the independence in 2002, there was a constitutional process, which was first the presence of the UN, aimed at building the country, preparing the country for the independence. In 2002, there was actually the formal independence and the enactment of the constitution that is still in place. This process, which I followed and somewhat followed, is what I call the Big Bang, and it helps us look at some of the at how constitutional building is also a process, and it's also not always a close and homogeneous process, given the result that we have in the end. I selected some issues that led to the constitution, to the present state of the constitution in Timor-Leste. One is the system of rule. Timor-Leste adopted a semi-presidential system, like Portugal and some other countries from Portuguese-speaking countries. But in Timor-Leste, it's interesting because it is the contingent result of the situation. There was one party, which was FATIH, that largely that had a large majority in the Constitutional Assembly, and there was a very charismatic figure, the leader of the resistance, Xanana Guzmão. So in Timor-Leste, this is not so much the result of a pondered political decision, but it is largely the result of the need to accommodate these two political figures. It's true that semi-presidentialism has been thought to be a better system for democratic transitions because it accommodates everybody. It allows for the representation of every factions of society in power. But in Timor-Leste, it was also the result of this particular situation. It's true that this was tested in the crisis. Can you come down because it's afterwards? This was tested in the crisis that followed, because someone said, some analysts have said that semi-presidentialism also creates conflict between the president and the head of the government. But the fact is that this is the result of the situation. I don't think that this is the cause for it. We could elaborate on that later. A second issue that in the constitutional process shows also how argumentative, if you will, the process is the option for the delimitation of the borders with Australia. The Timor-Leste had never accepted, Portugal had never accepted the position of Australia. Timor-Leste doesn't accept, only Indonesia accepted in the 80s because of the need to recognize its international presence. And this also shows a difficult relationship with what we call, what Schmidt said was the difference and the external difference in these processes and this argumentative nature. So this also shows that difficulty. The same goes for an interesting issue, which is the succession of states and the subsidiary legislation. When Timor-Leste became independent, there was no legal order to be followed from the new country. There was a dispute between the parliament and the courts, because the courts considered that, given that the occupation had been illegal and violent, the legislation de jure applicable should be the Portuguese one, whereas the parliament decided that it should be the Indonesian legislation, meaning that the legislation of the occupant, which was the reason for the war and for the declaration of independence, was applicable by the new country that had reason against that legal order, which is apparently would be ironic, but it's not if you consider that the people that were there were better aware of the legislation in place, even if de facto, than of the Portuguese legislation from '75, even if de jure that should be the case. If you can go down, I have written about this, and I will probably continue to do so. This shows,
if you could just start wrapping up, because we're running out of time, and we need to accommodate other proposals.
Yeah, just wrapping up. Yeah, going down to the conclusions already. This process shows the argumentative nature of constitutional making, if you will, the Big Bang of constitution. Whereas you find it's more of a process. It's more of a also political, legal, but also political process, more than with very interesting and always stark contradictions. That shows the difficulty of dealing with difference in these processes. Okay, thank you, and I'm sorry for taking up more of it.
Thank you very much. Thank you.
Let's move to the next.
Okay, let me introduce my poster, which deals principally with emergency and the terrorism in the Czech Republic. The goal of this research is to find out whether the current legal provisions regarding the emergency, which is anchored in the constitutional law, is also suitable to accommodate the threat of the terrorism, which is present in Europe and worldwide, as we know. Let me first give you some introductory remarks to the origin of the provisions that govern the emergency in the Czech Republic. The Czech Republic, or better say the Czechoslovakia, was formed on the ruins of the Habsburg monarchy at the end of the First World War. After that, this republic faced to the anarchism, increasing anarchism, and then to the Nazi Germany. The constitutional law, or the law governing the emergency at the time, tried to react to these threats. However, after the modern Czech Republic was formed after 1989, and then especially in 1993, this act was not transformed to our law. Up to 1998, we have no regulation of the emergency at all, despite the fact that our constitution presupposes that the emergency law should be adopted. It took 7 years from the 1993 to 2000, and then the law was adopted. However, as I said, this law was transformed from the First Republic and from the constitutions of the 1920 and from the emergency law, which was enacted after the World War I. So I suppose that this law cannot react properly to the threats that we are facing today. I show some excerpts from this law. We have 3 levels of emergency. First one is so-called state of emergency. Second one is state of national emergency, sometimes it's called a state of national danger. And the third one is state of war, which is, however, not proper for the terrorism threat. If I go briefly through the state of emergency, if you find it in the law, if you try to investigate what the purpose for of this state of emergency was, you will find out soon that it's suitable for the natural disasters. But if we want to accommodate the terrorism, especially if you look to the rights that can be suspended under this state of emergency, you will soon find out that it's not suitable. As you can see, it can probably react to certain terrorist attack, like let's say terrorist attack to the soft targets. But if we take, for example, the terrorist attack, which could be directed to the nuclear plant and so on, this is completely unuseful, let's say. The second state of national emergency, I will read it from this, can be declared when there is imminent danger to the state of sovereignty, territorial integrity, or democratic basis of the rule of law are in danger. I cannot imagine the situation when terror attack can threaten the sovereignty or the territorial integrity. Of course, we both know the ISIS, which govern now or declare the state in Syria and in Iraq. But I suppose this is not the case of the Czech Republic, and nothing like this is going to happen in the foreseeable future. I hope. Next thing I would like to mention here regarding the emergency scale of the terrorism threat. This was adopted after attack in the Paris and in the Brussels. Actually, we know that there are 3 types of the alert: the yellow one, orange one, and the red one. When the yellow one means that there is an increased vigilance, which is now valid in the Czech Republic. The second one is orange, over here. And this means that there is an increased terror threat, but we have no information whether the attack can occur or where it can occur. And the red one means that this terror attack is imminent. That sounds very nice. I read some report to this, and it should delineate rights and freedoms which can be suspended, and also it should delineate the right duties of the security forces and the possible measures that can be taken. This was adopted at the end of the March 2016, and now we have July, and still we know very little about this law, despite the fact that the first degree, the yellow one, was declared. My conclusion is that current law governing the emergency in the Czech Republic is not able to accommodate the terrorism because there is a lack of the rights that can be suspended in the first example. And in the second one, this is not suitable due to the potential to, due to the lack of the potential of terrorism to endanger the sovereignty or territorial integrity of the state. We therefore propose the new level of the state of national emergency. Let's say it could be specifically tailored for terrorism. This type is present, for example, in Slovakia, where the constitutional law governing the emergency explicitly mentioned the terrorism and have the list of the rights that can be suspended in those cases. I think it's more suitable, and we should work out in the Czech Republic to change the status quo. Thank you very much.
Okay. My poster titled Detaining Unlawful Combatant, Enemy Combatants in Israel, a Matter of Misinterpretation. Yesterday you heard Judge Barak speaking about a mistake that he made. I'll try to put this mistake in another light. I told him yesterday that that is what I'm going to speak about today. So he said that no matter what, he made a mistake. So it's the question is, what is the mistake? Okay, so in the US, you have since September 11 a big debate about detaining unlawful combatants. I don't want to go into this discussion, although it has some relation and ramification in regard to my issue, but I think that the US can learn from the Israeli, to learn from the Israeli experience, because we have about 30 years of experience in the problem. I have to have to give some historical background. The historical background is that since the late 1980s, Israel has been detaining unlawful enemy combatants, let's say from the Islamic terrorist group Hezbollah or Hamas, and so on. And this has been done solely for the purpose of having a prisoner of war. That means that Israel detained members of Hezbollah solely for being used as bargaining chips. This is the name that the petition that were against this practice called bargaining chips, in order to use them in a swap deal in regard to our prisoners of war and the MIIs. Now, what happened is that in 2000, this was done according to the Emergency Power Detention Law of 1979. According to this law, you can detain a person that poses a threat to security, and there was no problem in detaining Hezbollah terrorists according to this law. In 2000, you heard what happened yesterday when Judge Barak told you about the case that there was a hearing. They were detained since the late 98, since the late 80s. The case that Barak spoke about was in 2000. And what happened there is that they decided, a majority of the court, after a further hearing, in the first hearing, you heard that what happened is that the detention was allowed. And in the second hearing, what happened is that Judge Barak switched sides. They have a larger quorum, not from what he said, that from 3 to 9, but from 3 to 5. And he switched sides. And the fact that he switched sides, this tilted the whole jurisprudence. What happened is that they decided that you cannot detain, according to the emergency power law, you cannot detain a person which does not himself pose a threat to security. You have to show a specific threat from this person if he's going to be released. That means if you think about it, Hezbollah warrior, if you are going to release him, there are, like, say, 100,000 Hezbollah is not going to change the balance of power between us and Hezbollah. So you cannot detain him. You can, until today, you can detain, let's say, someone who is digging tunnels, and he has special expertise for digging tunnels. Okay, this is important because if he digs tunnels and no one else can dig tunnels, so you show that the imminent thing from him justifies detention. What happened after this decision of the Supreme Court is that actually the Knesset, Israel parliaments, promulgated a new law. Because what happened is that, first of all, they released 14 Hezbollah soldiers. And after they released them, another petitions came. And part of the petitions were this Dirani that we spoke about him yesterday. He was himself culpable in the kidnapping and abduction of one of Israel's MIIs, which is Ron Arad. He was himself, he abducted him himself. And what happened is, nobody really knows what happened. That's why they interrogated him. Either he sold him to the Iranian, or that the Iranian came and kidnapped Ron Arad from him. So it's Dirani himself tried to get released by the new ruling of the Supreme Court. So what happened is that the Knesset, which could not allow this situation to happen, that Hezbollah is holding our prisoners of war, and we are not we cannot detain their prisoners of war. The Knesset is the detention of unlawful enemy combatant law of 2002. In the meantime, the Hezbollah kidnaps another Israeli soldiers, and what happens is that there is a swap, and Dirani is in this Supreme Court, and the Supreme Court have a new interpretation. What he interpreted this the detention of unlawful enemy combatants, he interpreted it as a territorial interpretation. The detention law of 1979 is the detention law in Israel, and the detention and the emergency regulation of the mandate period is in the West Bank. And the new law, the detention of unlawful enemy combatants, you can detain from you when are in Lebanon and in the Gaza Strip. It's like when you want to detain people, warrior soldiers from, let's say, Lebanon or from Gaza Strip, you use this the detention law and the unlawful enemy combatant law, and court returned to its understanding that you can detain only if there is a specific threat from this specific person. So actually, the new law didn't change anything. My article is trying to argue that that it's building on a reality. I call it the reality of collective responsibility. I think that in the end, you have the paradigm of war. The paradigm of war is that when they hold your prisoners of war, you can hold their prisoners of war, and when the whole war ends, the prisoners of war returns. There is, of course, the paradigm of criminal justice. It doesn't. I understand that probably I need to sum up. So there is the paradigm of criminal justice. It's also, it doesn't suit the war on terror. The war on terror doesn't fit not the paradigm of war and not the paradigm of criminal justice. We need a new paradigm. The problem is that the question that I think it's not an easy question is the individual the ultimate unit of action and responsibility, or are we as individual responsible for the action and deeds of the groups of which we are a part? We are a part. So what happens is that, in my opinion, you have to, in this situation, you have to adopt a mixed theory of detention, which is not based solely on personal responsibility, but some kind of a mix between personal responsibility and a collective responsibility, and associative theory, which what I'm trying to get is that you can detain someone, the detention should be based also on who this person is. For example, high-ranking commander versus low-ranking officer, and not just in regard to the threat that the specific threat that imminents from him. And of course, after, even if you can detain him, it still has to be according to proportionality and limited in time. And so in the end, we reach very similar result, but there is a strong justification and understanding that this person is a part of something which justifies detention. We are not just detaining him because there is some kind of imminent threat. Because what's happened is that everything is become it's like pretext. Because if you say we are detaining you because you're a threat, when we know that it doesn't matter, I think it's worth it's problematic, because it's better to tell the truth that we detain you because you are central part of a terrorist organization, and this is part of your group, and this is your identity. Of course, has to be a test that in the poster you could see that I saw all it's problematic. I'm not saying that it's not problematic. Part of the problem of a terrorist organization is that you see that today they privatize the terrorist organization. It's like they put stuff in the Facebook, people read it, incited by it, and so it's a less formal organization than what we used to in the paradigm of war, which are standing armies and a command center and everything. So thank you very much.
Okay, I'll be brief because I think everyone likes fresh air at this point. So, title of the presentation is In Pursuit of Power, Britain's Common Law Constitution. It's reflective of quite a large chunk of my PhD research, which is relatively recently finished. Some of the terms I use in this title are quite deliberate. So first of all, Britain. When I was looking for a PhD topic that was allied to the concept of emergency powers, I thought, well, I'm Irish, even better, I'm Northern Irish, I've lived through an emergency, let's go with that. However, in terms of academic discourse, the Northern Irish emergency has been covered quite well, let's say. There was little fresh light that I could bring upon it. However, studying in England had its advantages. I thought, well, maybe let's look to the British domestic experience of the use of emergency powers. And while there was quite, the academic literature on that topic was reasonably sparse, if you look to the archives and look to what the key actors, policymakers, ministers, civil servants have been talking about over several decades, well, there was quite a rich repository of information and debate and legal opinion that I could tap into. So the British have been very good at exporting emergency powers in their empire to Ireland, and Palestine, etc. There's been very little perspectives on, well, the internal, the domestic experience of emergency. So, as many of you will know, Britain, well, the United Kingdom, to be more precise, doesn't have a codified single constitution. It's rather ramshackle. It's all over the place. It does have a constitution. It's just not, I can't say, well, here's a constitution. This is the British Constitution. So in terms of, well, the time periods that I've looked upon here in this presentation are about 16-year period in the first quarter of the 20th century. So at this point in time, when we get to say 1910, the years before World War I, it was thought, in British legal thought, it was perceived that in a emergency, in a crisis, there's no suspension mechanism like there exists in somewhere in France, état de siège. So what Britain has is a common law-based constitution, and from within that common law, there's no suspension mechanism as such, but there are powers that we can draw upon, and they are, when they are exercised, they are largely tested for their legality on the common law concept of necessity. So it's difficult to see that play out in reality because so few cases of British, say when a soldier was deployed in a time of civil disorder, particularly this time period, 1910 to 1926, it's a very formative period in the emergence or design of Britain's emergency law framework. But in this time, we don't see many actors held accountable in the courts of law for what they did. But the theory, at least, was that you could challenge, say, when 1911, when the troops go into South Wales in a coal miners' dispute, shoot dead 2 civilians in Llanelli. The theory was that soldier and his officer, according to the law, based on the concept of necessity. Don't see any, there is no case law in that. Nevertheless, that is the theory. In an emergency, there's no suspension mechanism within the British Constitution. Therefore, we look to the flexibility, that concept of necessity, through which we can judge key actors' acts. So, like I say, 1910 to 1926 is this very formative period in the design of emergency powers in Great Britain, because 2 challenges. First of all, industrial discord on an unprecedented scale. And secondly, obviously, the First World War, and part of that challenge related to industrial discord, of course, played into World War I. So, in the British legal system, there are essentially 3 sources of legal power. First of all, the common law-based principles. Those principles have been defined by judges over several centuries. There's also statutory law, legislation, and from within that there's delegated legislation as well. And thirdly, there's this medieval legal concept of the prerogative power, which over several centuries has transferred in its application from the sovereign, king and queen, to the hands of the king and queen's ministers, even further down, that translates down into civil servants. In the period 1910 to 1914, when there were these really quite profound challenges of this industrial discord, and this man, the young Winston Churchill, was Home Secretary. And I should say, preface before I get into this, my approach to understanding British experience of domestic emergency is based on looking at the archival evidence. It's not exclusively archival, but it's primarily archival. So if you want to know what the law was at any given point in time, of course you need to look into the archives as well, I feel. And at this time, in 1910 to 1914, the debates that were going on within the British administration in Whitehall, in which Winston Churchill was a key but very, choose my words carefully here, very, come back to, he was a loose cannon, shall we say, in his approach to, like a bull in a china shop, you might say. Maybe Britain's greatest ever person, but 1910 to 1911 he was an absolute liability. In any case, in the deployment of troops throughout Britain.
Speaking, rule of law was not his strongest suit.
Well, I can't. I mean, I can't speak. I look at the stuff he was saying at this point in time. He was quite more hopeful, and yeah, he was the guy that was needed at the right time. So, you know, okay. So before World War I, like I say, the theory was there's no suspension mechanism within the British Constitution. You judge. You both draw your power from the concept of necessity, and you're also judged against that judged in that exercise of power against that concept of necessity. So troops are deployed all across the country to face civilians. Sometimes this leads to fatalities. Ultimately, this is never tested in the courts, but the principle remains that Britain's emergency is governed by common law principles. Radical change, 1914, 3 or 4 days after the war, get the implementation of the Defence of the Realm Act. It's about 150 words, but it's, I'm going to talk about this a little bit later in the commentary. It's quite a profound statute because it leads to the transfer, the delegation of power from a primary statute to a secondary statute where civil servants and ministers can create regulations related to the war effort. It also is this Defence of the Realm Act is the prelude to what happens in 1920 with another mass industrial strike, and Britain gets, for the first time, a concept, a statutory-rooted state of emergency along the same lines as exists across continental Europe. The Emergency Powers Act, like I say, is rooted in the Defence of the Realm Act, which is specifically tailored to deal with the war. You can imagine, after 4 years of using these quite profound legal powers, that the civil service administration, ministers in Britain get very used to using this, quite enjoy using these powers. Why go to Parliament and enact prime, why go through all that hassle of enacting primary legislation when you can just do whatever you want, as long as you can justify it to some extent as grounded within a primary statute. 1920, like I said, we get the Emergency Powers Act, which again is comes out of the Defence of the Realm Act, but it's primarily supposed to deal with the re-emergence of this industrial strife that coloured the first 10 to 14 years or so of the 20th century in Britain. The paradox is that when we look then to 1921 to 1926, although the British government has access to this emergency powers framework, can enact a state of emergency, can then do all manner of things within the framework of the Emergency Powers Act. In the various crises that arise between 1921 and 1926 and culminate with the general strike in 1926, key policymakers, civil servants are very reluctant to actually draw upon those powers. So it might be that these positively worded statutes were thought to present a legal straitjacket in some sense. They could confine official action as much as they could empower it. So maybe it was that civil servants felt and government ministers felt that they had this quite radical parent statute to draw upon if they needed to, and to fall back on should their actions be challenged, the merits of their actions be challenged in the courts for legality. but they were not willing to explicitly draw upon, in some circumstances, they were not supposed to, they did not specifically draw upon these far-reaching powers that they had. The last thing to say is in reference to that third source of emergency power, or any sort of power that exists from within the British Constitution, the prerogative. Prerogative in this time period was not just not relied upon, it was explicitly rejected as a source of emergency power in the time of crisis. In this time period, 1910 to 1914, the British administration specifically drew upon, like I said, the repository of Commonwealth powers. This time period, 1940, well, First World War, they're explicitly drawing upon the Defence of the Realm Act. The State Powers Act, after the Defence of the Realm Act came to an end. They go back to the common law. They do not use prerogative yet in Britain. Today, the administration of Whitehall believes that it does have a prerogative power to act, to use, to draw upon in a time of crisis. I think that's fundamental and sound. The archival research doesn't reveal that. Not only does it not reveal it, but it explicitly rejects that premise. So I guess that's something you can ask me about if it interests you. Okay, thank you.
Okay, guys, we don't have much time, so what I suggest, we want to do this really short group photo so everyone can remember the symposium. And then we'll have another 30 minutes of break before we get to our final panel, right? And when we finish, it's supposed to be about 4:30, 4:45. Then whoever wants to join us, we will go to the High Observatory. Okay, so we can all go as a group. All right, time for one.
Yeah, bring it back the way it was. Yeah.
Yeah, we Timon, that's the first time they can see
continue.
But the one exports it's very contested issue because too much mutations.
Okay, we're going to reconvene in about 1 minute or so. So for our wonderful, thank you everyone, and thank you for indulging us for the photo. You'll get a copy of that at some point, or just press like on the Minerva Center Facebook page, and it's probably going to be there. I think we should all like the Minerva
we should all like
Facebook
ourselves.
page. Yeah. So for this final panel on political emergencies and political trauma, we have 2 papers, of course, and Joshua will opening remarks on Dan's paper. Just want to make sure that Joshua has the microphone ready. Yes, great. Fantastic. Joshua, thank you.
Okay. First, it is a great pleasure to offer some comments and remarks on Professor Dante article, Reluctant Radicalism. His goal is to demonstrate and critique the Philippines Supreme Court's reluctance to assume a new and more powerful role check on the exercise of emergency powers, specifically the powers to review the factual basis of emergency situation, a role which, according to Professor Katmaltan, is outside the classical separation of power, and the court the court's jurisprudence adopted a near impossible standard to check the president's power to call out the military. The standard for review adopted by the Philippines court is that the president's decision is totally bereft of factual basis. Professor Gatmantan also sheds lights on the pattern of judicial oversight in the last 30 years or 40 years on the exercise of emergency powers in the Philippines. The jurisprudence show time and again reluctant to intervene in the president's taken course of action, in no way required or justified by the circumstances of emergency. Thus, in my opinion, the Latin phrase inter arma silent leges, which literally means that in times of war law is silence, has translated in the Philippines to mean if the president wants to silence the law, he often use the pretext of emergency circumstances. For those of us who are not expert in Philippines constitutional law, this article supplies a very broad information, necessary information to start a fruitful discussion and conversation about judicial review in times of emergency, and does so very effectively. Professor Gatmaitan argues that the Philippine experience reflects two schools of thought that dominates the discourse regarding the judicial review of action arising from political trauma. This is the phrase he uses. about political trauma. Maybe the court is the judge is some kind of a doctor or a mental doctor. The accommodation, there are two schools of thoughts. One is the accommodation view, which under it, the Constitution should be relaxed or suspended during an emergency. We know this view from other writings, and there is the strict enforcement view, the Constitution should be absorbed strictly. It already provides the necessary level of protection for civil rights and taking into account the interest of the government and national security. Professor Maitan is, of course, supporting the former view, the strict enforcement view. He explains that the law of emergency refers to abnormal, unpredictable, and exceptional crises and circumstances. He notes that most of the legal systems do recognize the law of emergency as last. However, it should be viewed as doesn't quite fits. If I use your words, it fits quite uneasily with modern regimes. Which brings me to the whole question of which is based on at least partly on our ability to predict and foresee the future and the constitutionality and the rule of law. We talked about it supposedly for the last days. All of this constitution and the rule of law are meant to create an order and a formal structure that, despite the changing circumstances, and that are meant to order and to house the changing political power. Now, by adopting basic norms like equality, the rule of law, proportionality, modern law tries to narrow the playing ground, in my opinion, of fate, of luck or bad luck, and of arbitrariness. What Professor Maitan is arguing for, he argues that the Philippine Supreme Court should not wait for in his review for the parliament, for the consent of what happens in the Philippines, that you have the president can declare a state of emergency. Sometimes he does not declare it, but he can excuse. But then in 48 hours he has to achieve the consent of the parliament, and in the meantime, what happens is that the court established that you can come to you can petition the court only as a last resort, while Professor Maitan its role is not as a last resort, but rather provide multiple and simultaneous avenues for redress. Which, from one end, I'm pretty sympathetic of in this about such a goal and aim. On the other hand, I have some concerns. First of all, what what the paper lacks is some kind of background about the institutional mechanism that establish an independent and impartial judiciary, because in the end, the situation that the Philippine state have been into, I can't see how a judiciary could save the nation, could save the day, because when you read that thousands of people were murdered and thousands of people have been abducted, and so you wonder where was the judiciary, but you think about what would have happened if the judiciary intervened and let's say try to release these prisoners. I'm thinking, what is the role of the judiciary in such a situation? Could it help in that situation? This is the Marcos era. Okay, after the Marcos era, so it's a little bit different. But again, it's a real crisis. First of all, I have to say that for me, a real state of emergency, we talk about exceptional, it's always come to my mind Immanuel Kant's saying that necessity knows no law. So if it's really a matter of state of emergency, the real exception, you can't talk about law and everything. It's simply something which is out of the normal or and the abnormal substance of modern law. But another thing that I was thinking about is in regard to the role of the court in such a chaotic environment. Do we really want to say that or believe? In my opinion, it's a little bit of a myth that the court could have saved the situation in this regard. We also heard the judge should be courageous and they should lead and not be led and all of that. But however, some doubts starting to creep in, because in the end, it's one of the American Supreme Court, I don't remember his name. I tried to, in the last week, try to find his, the specific saying, but one of the Supreme Court said, in the end, the Supreme Court, when he was talking about the American Supreme Court, is a bunch of lawyers. Okay, so what a bunch of lawyers can do in an upheaval of murderous in a war situation. I'm not, maybe. You know what? Maybe. You know what? I will quote this. So I will quote Judge Oliver Wendell Holmes. So I'm just teasing you because you give a lot of trust in the court that he will save the day in his review, and I will quote Judge Oliver Wendell Holmes. If maybe it's worse. So he said, if the citizens of the United States choose to go to hell, my role as a judge is to lead them there as soon as possible. So I'm not saying that. I'm just let's not put all our eggs in the basket of the court. I think that there is a lot of sense in letting the procedure play along, let the president go to the Congress and get their authorization. And the court, I do think one thing that I do agree is the case of habeas corpus. I think this situation of habeas corpus, when you see times of troubles, times of war, the danger for liberty is by suspending the habeas corpus. So, and I also think that the court do have, in cases of habeas corpus, do have special expertise, because there is maybe no one, not all of you know the distinction, because the Supreme Court do have a review, a power to review for habeas corpus, but in the new Constitution of '86, they let view the emergency situation without regard to habeas corpus and without even asking someone to have standing. Every citizen of the Philippines can petition the court and he has standing. I find it, and what the court did is interpret that as, okay, everyone has standing, everyone can come to us, the last resort. Let the procedure plays out, and we will not decide. I think that what the court did is trying to take himself from out of the political process in order to be neutral, in order to have some objectivity. Because in my opinion, in such an extreme condition, in such a, and here I'm building on Paul Butler, he has an article that names, I don't want to take someone credit on something that he has an article named When Judges Lie and When They Should. When a judge is faced with injustice. And it's I agree that the cases that you brought in the article are all cases of injustice. But what should a judge do in such a situation? He can enforce the law. This is one option. The second option, he can resign. This is what the people thought that the Nazi judges should do, or the judges under the Nazi regime should do. He can ignore or disregard the law, which probably will make him fired, or he could lie. He can interpret the law in a way that reaches a result he wants, a result near what he wants, by saying the law requires something else than what he believes the law requires. And the reason is because he thinks that he could have some kind of a contribution in the future. And I think this is what the Philippine court tried to do. He tried to not to be an actor in order to be an actor in the future. This is my opinion. But again, I'm not really knows what the Philippine jurisprudence. This is how I read the decision that we bring. I do like what you said, that you give the quote from Justice Story. The court has done its duty. Let the nation know now do theirs. And you say my point is that the court should perform its constitutional duties regardless of the consequences and so on. In my opinion, the court has a duty to protect civil liberties and rights, but speaking openly, it doesn't achieve this goal all the time. This is my opinion. Sometimes you have to be. There is of course another things that I do have. I think that in regard to the Constitution of 1986, it's true that the Constitution told the Supreme Court, you have a basic, you have the authority to review based on factual, the factual basis of emergency situation. It's true that the Constitution said that, but in my opinion, the minute that you give someone authority, an authority is something that we get from others, but we also, it's a factor of our discretion, because we set our limit to what is legitimate and what is not legitimate. And authority is not just what others says, other people says about me. It's about also my decision in regard to what they say about you. So this is how I think that you can interpret the move of the Philippine Supreme Court. Thank you.
Thank you, Joshua. Dan, what we've been doing, as you know, is giving you an opportunity to seek clarification and make very brief remarks in response, but we want to give more time for people to ask questions. I think you might need a microphone. Do you think he needs it? Is it
rather use it?
Sure, I can speak loudly, I think. Well, thank you, Joshua. On one hand, I was thinking what the framers of our Constitution did was to end the debate on what courts can do when they are asked to review an emergency. And so I thought I didn't have to go in depth into the literature on that question because it's saturated. I think you can go to any library and find a book on that. So I wasn't actually thinking about the wisdom of the Constitution. I was just wondering why the court doesn't want to perform its duty. So just to give everyone a short background, during Marconi's time, the court essentially said the president can do anything, and his answers, and that's the reason why he got away with a lot of things. Everything was a political question, and that's the reason why our 87 Constitution is so long, because they tried to prevent all those things from happening again. And one of the things they did was say to the Supreme Court, stop dilly-dallying on this question. You have the power to do this, just do it. Oh. So because of that experience, the framers said, just do it. And don't come up with another case and change our mind. And, we don't know what the hell we're thinking. Oh, sorry. Just most of us thought that's going to be a turning point in our jurisprudence, but we're not seeing it. And I appreciate those things because over lunch I was asking, maybe you have a theory, because I really don't have one. What I'm thinking is they're programmed to avoid political questions. Perhaps they're programmed to assume everything is constitutional. So even if there is a change in the language of the Constitution, it doesn't follow. They don't automatically follow what the new Constitution says, because that might be what you're saying, that they still apply discretion even if they have authority to do it. But the fact is, there's nothing in the text of the Constitution that seems to justify the role that the court is assuming now, which is to take a back seat and let Congress do its thing first. And one more point, the problem is that the court doesn't give us an explanation as to when it will step in. They just said, if Congress procrastinates or defaults on its duty to review the president's actions, then we can do it. But it doesn't say when. What does it mean? What does it mean when they default? Because the last time they did it, they took days to discuss whether they were going to broadcast their review. The president lifted martial law. So they said, oh, our job's done here. That's what happened to us. So that might happen. If the court, we could have a situation where there is no review of the factual basis of martial law or any other form of emergency regime or situation that the president has under the Constitution. Thank you.
Thank you, Dan. Anif?
Thank you. Dante, I have two things. One, perhaps the theory that you're looking for rests within the idea of constitutional culture. Because what we're actually saying is that in the pre-1987 was always referring to the executive, and later, even though the Constitution explicitly allowed the court with the authority to review emergency, the court would still not intervene. But this is because this was constitutional culture. It's not a matter of constitutional text. So I think this would be one way to look and develop this idea. Second, I'm just wondering, what we see nowadays, although we live in an era of judicial activism, what we see now is captive courts. Captive courts everywhere. So we just heard this thing to do to take that 2000
literally capture.
Yeah. And we have the same now in Hungary. We have the same in Honduras, in Poland. I'm just wondering, what is the case in the Philippines or near the Philippines? Is there any history of symbolism? Maybe because you're saying, well, having already settled the issue regarding the role of the Supreme Court in political trauma, the court should exercise its power regardless of the consequences. But if the judges know that tomorrow they will be replaced, then they say, okay, on the balance, I'm not going to intervene this side. It's not worth it. I'll wait and I'll save it for later. Just imagine.
Yaniv, when you say the constitutional culture, could you also be meaning that it's generational, that the judges who are now sitting on the Supreme Court are from the pre-new constitutional generation? I don't know if that's true. Maybe Dan can tell us where these judges came from, how they were appointed. And I guess the question to you, for everyone, is how do we change constitutional culture? This has come up over the course of the past 2 days, and that's maybe a larger question for reflection, but that has been the answer to which we've all, not all of us, but several of us have turned. This is a matter of constitutional culture. Fine, I agree. How does that evolve? How does that change?
If I can take it one step further, perhaps during normalcy, we can all pretend as if we're abiding by the new constitution, the written rules, but during emergency, the real us reveals.
The real test.
We go back to the real culture during these times of emergency.
Yeah, thank you. Ilan.
Just to talk about the challenge of Joshua memory, I think that it's Roberts talking to part of his non-willingness to move in this direction, as he said, we are just but I'm not sure. Okay. About following what Richard just said, it's interesting, especially in times of trauma. You said the framers had this trauma in mind and they didn't want it to be repeated, and so they made a huge effort. So it's very puzzling, as I share your puzzle, of course, of why the judges don't feel the same. So I don't know the answer, of course, but maybe it's connected to what Emilio just said, that the us is different. In times of Marcos, the people of the Philippines was the us, the we. But now maybe it's the Muslim rebels or some people who are not us. I don't know.
I'm not.
Very briefly, I think it's fascinating. So the first question that you raise goes beyond, emergency, non-emergencies, but it's pertinent in emergencies, and that is, does text matter? So we have a long constitutional debate, empirical studies on that, when or to what extent text matters or matters less, and I think we haven't yet examined that question with respect to emergencies, and here is the puzzle. The more we think text matters, we would expect it to matter more in emergencies, because we have in mind a particular need for power, and therefore we want to regulate it very carefully. but then kicks in this notion, this business of necessity knows no law, and therefore, who cares about the text? There's reality. With all due respect to text, we have to react, and then text matters less in emergency. So it's more something for us to think and reflect on this issue. But so the first question is, does text matter? The reaction to this was among, I guess, Joshua and also Yaniv and Ilan. Well, maybe if text matters less, maybe context matters. And context can be the history that led to this, the culture that leads to this, the change of the perception of the we or the us. It's the imagined community, to bring in Anderson and the rest. So maybe context matters, and then maybe the context here is that the framers of the new constitution wanted to achieve that. There's a judicial reaction to that, saying, okay, we will fulfill this role. Other contextual, historical mindset issues or cultural issues in mind, we don't want to step in first. We'll allow other processes to take in, and then we want to develop institutional dialogue, constitutional dialogue, whatever it is that's part of the culture. I don't know, but I'm assuming this is something that we want to look at. The last point, so it's either text matters, context matters, but maybe it's institutional design, and this is somewhere that we haven't really looked at. And this notion of positive incentives, or the rational player, or all that. So if you look at the institutional economy here, you would ask questions such as, what about judicial independence? If they do something, can they be removed? What will happen to them after? Are they somehow dependent on government? This is one set of questions. The other set of questions, suppose you guarantee independence. And I have, as a court, I have some institutional capital. How spend it? By stepping in now, or do I spend it later by saying maybe somebody else can take the hot potatoes out of the fire or whatever, and then I will step in only if in cases that so it's a matter of institutional economy in the sense of I have capital and how do I use it. So it relates to institutional design, what will be my incentives under certain design. So I think all those variables may be informative of this fascinating case. And the last question would be, if this really, again, to tie one of the themes is to what extent it's jurisdiction specific or cross-jurisdictional, right? So juxtapose this with the South African example, which is the flip side, whereby the court during apartheid said, my role is actually to abide by the Constitution. And I'm not going to go the step further to do anything else. And it was criticized for that. So the question is, when do judiciaries behave differently? When do we expect them to step out of text or to be bound by text? There's a famous piece that research American in the antebellum years when they had to lie, when they wanted to deal with slaves, because the law said, okay, it's a slave, it's property. So you have to return the slave to its owner, even in states where slavery was outlawed. But it's property, and then you have to return it. And many judges went way beyond the text and said, no, the text is not the solution, the text is the problem. So they lied or cheated or did some other. There's a book called Lawless Judges that talks about this phenomenon.
The problem you raised, I think, is even more complicated. The actual design is not separate from text or context.
Right.
It's deeply embedded within it. And so I think it's important to separate it out of those two, but recognizing that it's within it. Right. Judicial appointment, judicial insulation from Congress or the Parliament. Now we're getting to the very difficult questions here at the end of the day. Antonia and then Ellie.
My point is very much related to that.
Antonia, the microphone.
Okay. It's about independence, because you mentioned independence just one time at the very beginning of your paper, but I'm not familiar with the system in the Philippines. So I was wondering, what does it mean independence and related to this? How the judges are appointed and how long is their mandate, and there are differences from before the constitution, the new constitution, and after. So I would like to have some highlights on how things go in your system. No.
Thank you. We'll give you a chance right after Ellie to respond. Ellie, please.
2 points. One, constitutional culture or constitutional mindset. I really don't think it's constitutional culture. It's actually a culture of collective action, collective decision making. It's actually a culture of political culture. And one of the problems of our time is that understanding of democracy is a very thin understanding. The majority can do whatever it wants to do. If you think about it, philosophically, majority cannot be justified not from deontological theories, not from teleological theory. Majority decision-making is a second best because we cannot reach unanimity. And of course, if you think about it from this perspective, what is very important in constructing collective action is the fact that justifiably collective action is reflection of taking into account all the views in society, not maybe 100% of the people, but all the groups that are represented. If one can think about what is the role of the judiciary in this context, and this, go back to the Federalist paper. The debate was about the Bill of Rights, one of the debates, and Madison said we don't need a Bill of Rights, we have a right structure of government that will actually change the decision-making rule from simple majority to supermajority or qualified majority. If you think about it in this way, that courts, constitutional courts especially, are representing the interests of minorities while government represents the interests of majority because it is voted by majority. Then you can play with these features together. So in a country in which you require 90% to pass a decision, you don't need a judiciary. In a country in which 51% raw majority rules, then of course the need for something that will balance the political decisions are much more important. So this is a factor of how many houses of parliament, the election system. What is there a separation between the executive and the legislature? All these factors come into play when you talk about the role of the judiciary. This is one remark. The second remark relates to the institutions, which is actually derives from what I said. Okay? Courts can play a role if they are not, if we talk about separation of powers or representing minorities, if they are not on the political branches. The Israeli case, which is quite interesting because our political system is basically the British political system, even minus, because we don't have two houses of parliament. We have one house of parliament with proportional representations. The government majority or the coalition government can do whatever it wants to do. There are no checks and balances, save the judiciary. That's the reason that from a normative perspective, the role of constitutional court or courts in general is very, very important. Why in Israel courts became such an important player? Because of the institution structure. It was an accident that we inherited the British procedure, for example, that we can apply directly to the Supreme Court. It was done for a totally different reason by the Brits. They wanted to hold in their hands all the powers, and at the time of the British Mandate, only British judges were in the Supreme Court and the local judges were in the lower court. Then there's a way in which judges are appointed, or tenure for judges, for example. All these features were crystallized in a law in the 50s, okay? And this gave the power, the actual power, from a positive perspective to the courts. So in Israel, there is kind of equilibrium between normative and positive analysis with regard to the role of judges. And I think that in thinking about this in terms of political theory, really the highbrow political theory, what is the justification for collective action? How can we justify a collective decision making in which some people are actually losers?
This is the way to think about it, and constitutional culture or constitutional mindset have to be deducted from the other components of the political structure.
So if we apply this, Ellie, to the Filipino case, the idea that we need courts where institutional consolidation is easy, right? Where the governing party does not have a strong opposition, or there aren't checks against it. And in contrast, you don't need strong courts, where there are a lot of veto gates, there's a lot of opposition. So that would suggest that the reason why in the Philippines the Supreme Court has not exercised its power as the constitutional text invites it to do in the face of emergency is because there are strong legislative, executive checks in the way of the governing party. Now, this is a question to Dan. I'm saying if that's the theory.
The second component is if judges are appointed for life, or till retirement, they cannot be get rid of, cannot be impeached. That's the criminal. If judges have salaries that cannot be cut by the executive, if judges, if the method of appointment judges is not political, and there are in our system, for example, which I think is a very good system we have, for all judicial positions, an appointment committee, which is comprised by 2 parliament members, 2 government ministers, 2 bar representatives, and 3 Supreme Court justices. So it's the 3 branches of government plus the legal profession, and you have a majority to the professions over the politicians. This can guarantee that the judges that are appointed, not that they are not political or ideology is not taken on board, but you can imagine that in such a system, judges will not be less than of politicians. So all these structural elements are incorporated into the philosophical, the political philosophy concept that courts should be some kind of balancing, checks and balances on the political power.
So this is a theory, Dan. How does it work in practice in the Philippines? Do you have the microphone?
Sure.
I have a sense you're right.
We have all the guarantees for judicial independence except the Judicial and Bar Council, which gives a president so he can choose from that list. The problem with our model is that the president pretty much decides who belongs to the council. So in practice, if the president wants a friend, and that's the last appointment by President Aquino, we knew he was going to appoint his friend. He couldn't even pretend to consider anybody else. And true enough, a day after the list was submitted, he appointed his friend. So that's a problem. But all the suggestions are actually plausible. Now I have to choose a theory.
Well, isn't the Philippines, isn't it the 87 one? Isn't it patterned around the U.S. Constitution? The idea of strong separation of powers, in which case the theory of the checks would work very, very nicely for you.
Our 35 Constitution was approved by the American president, and it's like, because we were a colony, and they would not let us go until we drafted a constitution that's exactly like yours.
Okay.
So all those principles are already imbibed by lawyers and by, to some extent, the community. The 87 Constitution was more of a check on where we failed to repair all those provisions that were abused by the president. And that's why we now have all those provisions strengthening judicial independence, etc. So, but despite that, the courts acting on the authority that we've given them.
So just a quick question, just a follow-up, quick question. So suppose a petition was brought to the court against the nomination of this new judge because he's a friend of the president, and everybody realizes that's not really serious because he's not of the quality. And suppose the text of the Constitution said that the president is bound by the rule of law and can only consider relevant consideration, and if the president considers irrelevant consideration, if the president asks who traveres? Would you expect then the court to step in and say, well, the text says only relevant consideration. I have a strong suspicion that this is an irrelevant consideration. I want to conduct a judicial hearing about the evidence that the president has with respect to the nomination of the judge, or bring in this business of culture and judicial culture and say, the role of the judge, or what I have in the pantheon of judges that I see before me, are those people that intervene only if it's really necessary. Don't mess with politics, allow other venues or other recourse to other channels to work themselves out, and only as a last resort will intervene.
In theory. The constitutional justice, one has been known for integrity, probity, independence, etc. Very vague concepts, which is probably why your case will be thrown out. In one particular case, when the list is made public, anyone can question the integrity of this person. But presidents have been known to appoint even the most notorious person in the short list. And once that happens, the only remedy we have is impeachment. And that's the Supreme Court has made several decisions saying, you want to get rid of one of us, you have to impeach us. So that's how fascinating life is.
Yes, Guru.
Looking at this from the post-colonial lens, one of the challenges that even India faced, even Nehru had a problem with Jawaharlal Nehru for all his federalisms. The problem that he had was he thought the judiciary brought in a culture of elitism and of the colonial legacy as well that would prevent the legislature from bringing in far-reaching changes to the post-colonial society, ideas of revolution, of land redistribution, so on and so forth, which the Indian judiciary at that point was blocking through the notion of the right to property that is found in the Indian constitution. So for them, the judiciary, for Nehru and the Congress that represented, the judiciary represented colonial era elitism of not understanding the ideals of revolution that were embedded in the anti-colonial movement. And so for the Indian judiciary, they were sort of quote unquote tamed during the Nehru era, the taming of which also led to the Indian judiciary condoning and agreeing with Indira Gandhi's emergency rule. You find that in a lot of South Asian democracies. It's true of also Sri Lanka, where the political elite found the judicial elite to be problematic in the kind of revolutionary ideas, quote unquote revolutionary ideas. So the question that I had was, is the counter-majoritarian assumption, I mean, the philosophy of liberal constitutionalism, does it somehow not fit the kind of revolutionary constitutionalism ideas that are embedded in the anti-colonial, post-colonial movement that has had a hangover effect for all these years, that is sort of carried on, where the judiciary finds itself not able to accustom itself to the idea of it being a counter-majoritarian institution. That they think that being subservient to the idea of majoritarianism is also a continuation of, is the best democratic way of doing things in the post-colonial context. I wonder whether those ideas of revolutionary constitutionalism is pitched against liberal constitutionalist ideas in Philippines.
I want to answer this one. I agree. The problem with us, the 87 Constitution contains a lot of what we call progressive provisions. It's the most politically correct constitution you will ever find because everyone has rights. Women have rights, indigenous peoples, there's very strong provisions on agrarian reform. So on paper, it does seem like if we just follow the values that we have injected into the constitution, then it is a majoritarian institution. But they will decide, in cases come up before them, initially they will rule in favor of the distinct minorities. But eventually, in almost any field, they tend to become more conservative in their later decisions. So while you have incredible first decisions on agrarian reform, they start talking about changing the world, etc. That will end pretty much after like a couple of years. Very strong ruling on indigenous people's rights, and then if you examine the following cases, there it's the court that is cutting down on the rights that are mentioned in the Constitution. So that's where we are on that issue.
Well, Dan, we look forward to reading which theory you end up choosing to explain this phenomenon.
Developing a new.
Developing, that's right. That's right. Yeah. Thank you to both of you. Joshua is not here to get our thanks, but we'll relay our thanks to him.
Okay, thank you, Richard. So we will be moving to our final paper, Young's paper on political emergencies, challenges during Rochelle is coming from. And we have FATIH Ground to start this comment.
Okay, thanks, Johnny. First and foremost, fascinating paper which combines the signature of 150 years or so of Crises rich, too rich, some might say, constitutional and political conflict with a correlative or underlying theory of public law. Janus's paper is in the premise of discursive political democracy and the balance. You got a chance to try out the venom from, firstly, the decisionism inherent in Carl Schmitt's for the critique of political liberalism, and secondly, the ostensibly nihilistic excesses of constituent power in its disregard for normative requirements of government by consent. The energy behind Janus's paper is a desire, motivation to design a substantive framework that might serve to overcome that differential opposition opposed to political liberalism. The dramatic climax of which we're all now very familiar, is that jurisprudential setting of the exception to exception, the naked essence of sovereignty is revealed, in which the state remains law receives the suspension of the liberal democratic order, when an arbitrary sovereign authority. My comments proceed as follows. First, a quick overview of the Janus's project. Secondly, references to a couple of thinkers that Janus is not explicitly draw upon in this paper, I think certainly complement his own project. And thirdly, a few words on Janus's conception of consistent power. So an eye-catching early section of Janus's paper, to my mind, lies in his decoupling of political theory from Schmitt's, the latter being the admirer of the former. Hobbes's silver rule, as Janus calls it, of impartiality, which is derived from prudential practical reason and provides that it orders for the foundation of agreement and resolving disputes and disagreements. That provides the basis for creditors' judicial feelings. From this construct stands the citizens' buy-in or stake in the constitutional rules of the game and whether equality. That is, we might not like the ultimate decision, but at least we can respect and abide by the procedural mechanisms. It's a negative construct that advises abstention or duty, advises to avoid certain forms of behavior or prudence. And Janus's employment of Hobbes in this manner serves to provide the antidote to the brutality which springs from the outworking of Schmitt's friend for whole binary distinction. It is that dialectic which covers every single aspect of Schmitt's critique and forgiving liberalism, the avoidance of potential conflict against overcoming sovereign authority. Janus then takes us on a study of Greece's post-1875 constitutional order and the various modes through which emergency was generative of structural constitutional change. This is a point I will return to later in the context of Janus's discussion of constituent power, with specific reference to the 1974 transition to democracy. There are a couple of elements or aspects of Janus's paper which immediately grabbed my attention because they ally to my own research interests in constitutional crises as well as civil unrest. So spend a little bit of time highlighting them first. Firstly, with respect to the ongoing sovereign debt crisis, Janus briefly points to how the ruling, the Greek Parliament, has been largely sidelined by the executive's excessive recourse. What's under the rubric constitution I'm familiar with, the British Constitution, the term delegated executive legislation. I can't speak more on the Greek perspective beyond that which I find in Janus's work, but with this usurpation of the legislative function in time of crisis, that's something I'm very familiar with in the context of British experience of emergency. For example, in the context of World War I, which I spoke about earlier, with the passage of the Defence of the Realm Act, a rather innocuous looking 150-word statute, even affectionately termed DORA as its acronym, which allowed the executive to then pass extra parliamentary legal regulations to protect the realm, which encompassed everything from execution for those who were found to be liaising with the enemy to even regulating climate heights, with a lot of work in between. In that regard, normalization of the exception is a theme that we turn again and again to in order to better conceptualize the great strain placed on constitutionalism in the time of crisis. In the application of such delegated legislation, Janus talked about, and I just talked about a different setting, by stealth is perhaps most emblematic of that normalization. Is indicative of traditional crisis governance scholarships, for example, that undertaken within the roster over half a century ago, 67 years ago, we tend to portray such movements as part of the almost neo-Whiggish narrative of constitutionalization of crisis governance powers. In other words, the definitive prescription of the range of authority available in an emergency to the executive. But while statutory emergency powers are relatively manifest and distinct in vagueness, in contrast to the vagueness of emergency powers grounded in more abstract notions of divine and prerogative right, they can still be as far-reaching and as, if not more, damaging to liberalism in the absence of any adequate judicial parliamentary oversight. With reference to the concepts of the principle of legality, the same principle that emerges to confine or constrain those abstract prerogative powers, i.e. parliamentary democracy, as the ultimate form of constitutional authority, has in fact resulted in what you might consider a neo-Schmittian nightmare of vast tracts of discretionary power and authority in a unitary sovereign. It's what Lord Gordon Muir, former Lord Chief Justice of the United Kingdom, 1 century ago described as the new despotism in his seminal book. The stability of the public law that is grounded in practical reason is the pinnacle of the successful handling of an emergency. More broadly, as a bulwark to the advance of the Schmittian Water Cameron, I find resonance in Janus's paper in the work of David Eisenhower and his rule of law projects. Those projects all have in common a core principle in the form of the non-negotiability of moral resources and the principle of legality in the Constitution. In turn, there are, at least in my mind, in Janus's work, shades of a Bocconian theory of adjudication law as integrity, and I raise that comparison with slight nervousness, to tentatively approach the matter of Janus yesterday. Looked at what it means, so I didn't quite agree with that. But it's what I have in mind there is Dworkin's moral reading of the Constitution, which is explicitly anti-majoritarian premise. That in turn is a key driver of Eisenhower's normative framework as an construct. In Freedom's Law, Dworkin writes that the defining aim of a democracy should be to ensure that collective political decisions are taken by political institutions which treat all members of the community as individuals with equal concern and respect. In order for that conception to be sustained, Dworkin then asserts that it's crucial that democracy is supplanted or supplemented, I should say, with a non-majoritarian procedure simply declared on special occasions, when this would better protect and enhance the legal status that is declared to be the essence of democracy. Of course, the non-majoritarian procedure to restore court affairs is the judiciary in order to bridge what Schmitt calls unbridgeable hiatus, which he claimed existed between those abstract legal norms and particular situations. In order to bridge that and show Schmitt to be wrong, we must demonstrate how those principles could be said to be found from within the law, such as the right to moral independence, which can be applied in particular situations as a means by which an individual can challenge executive power, which fails to adhere to a substantive concept of rule of law. Those sentiments, again, to my mind, are echoed in those parts of Janus's paper which weave together the mechanics of a strong deliberative parliament, with strong oversight capacities, and prudential judicial oversight, which can control the subjectivity of the political declaration of Finally, a couple of words or sentences on constituent power and popular sovereignty. I do so with specific reference to part 6 of Janus's paper, which describes that fascinating melange of continuity and change, as Janus puts it, which coloured Greece's 1974 restoration of democracy. This nascent pluralistic constitutional order encompassed a rejection of a constituent assembly on Janus argues prudential grounds in favour instead of a revisionary assembly. This is the embodiment of constituent power, Janus writes, where in a moment of political crisis, people choose to reconnect with the past, choose to reconnect with the past. That is the old constitutional order, a known quantity, the continuity, not change, thus avoiding what Janus describes as the unpredictable consequences in time of crisis. I'm not so sure that that is a negative problem power, and I'm not sure that that's the argument that Janus wishes to make. The way it's not clear to me. Or is it that there are different variants of constituent power, some benign, some more malign? I say this because Janus goes on to make the argument that the 1974 constitutional upheavals decoupled the normative magic of revolutionary constituent power. He goes on to argue that the generative nature of constituent power should be confined to the dustbin of what he calls the pre-history of constitutionalism, and that in its place, in moments of high political drama and emergency, should be cited the resolutionary mechanics of prudential practical reasoning and public deliberation. So if we are to understand constituent power as the rational modern expression in constitutional vocabulary, that which specifies the ultimate source of authority in any given jurisdiction, why be embarrassed about it? Think of constituent power or authority as a malign force after constitutional Big Bang or revolutionary movements. It is or can be thought of as the end result of a definitive act of self-determination. Potentially, therefore, it could be a stabling force, a benign force, between constitutional legitimacy and order. Therefore, the point is that it doesn't necessarily, it's not entirely clear to me why we should shy away from or abandon it after that Big Bang moment, after its generative moment, which is the expression of the constitutional order's dynamism and openness, because constitutional legitimacy ultimately depends on the consent of the people. Post-revolutionary constitutional power can be a valid constructive force embodying the consent of the people, operational after that generative moment, I would say. It seems to me that in Janus's what I call rule of law project, borrowing on Weissenhaus's terms, a Schmittian precisionism underpinned or complemented by raw constituent power is resisted or bulwarked by an anti-majoritarian constraint, i.e. Bocconi circuit breaker. This is absorbing stuff, but it does conjure to my mind some uneasy portents. Whose practical reason? What is our reference or measuring point for defining and controlling that? Is it ultimately participatory? Is it the practical reason of elites? How do we bring order to those discussions and afford due weight to the inevitably competing conceptions of power dynamics? This is as much me thinking out loud as a non-legal theorist, as it is a direct comment in this paper. If constituent power is, as Janus argues, the root of popular sovereignty, which he similarly treats as self-referential and naturally disposed to violence, then what happens when we deny popular sovereignty? What happens when we deny that ultimate root, like constituent power? Does it perhaps not give credence to the Schmittian argument that whereas liberal theorists merely obfuscate over the true nature of sovereignty, he, Schmitt, by contrast, gets closest to it, and whereby liberal theorists construe the state as a purely formal structure, by contrast, Schmitt vows that the state is a specific entity of people. Finally, and furthermore, as we watch the rise of Trumpian authoritarianism, Putin, Erdogan, or even closest to my mind, the gross distortions of fact that were spouted by both sides in the UK's recent European Union referendum. It's not state in the Western world, some might argue, quasi post-truth politics, or how do we foster true practical reason, public deliberation for it. It's nothing to keep me awake at night. Yeah, that's all.
like to thank Patrick very much for this comprehensive, accurate, long remarks. Actually, the starting point of my paper was a kind of dissatisfaction with what I think that it is, to my mind, it is a very broad and without keeping the right balance, an active analysis by Carl Schmitt, which has somehow influenced the whole discussion of emergency, the analytical framework of emergency, which comes from this very relativistic notion of justice that existed in the pre-war beginning of 20th century, with probably the Vienna School and that tradition being the most the clearest example. And there were what you get is that somehow a kind of destabilized the assumption of an indivisible community. Then you go to the situation where those who hold power exercise sovereignty by declaring an emergency. Now this is totally unsatisfactory, because this is exactly where the discussion starts. It doesn't end constitutionally. It should start at this point. And it should start in the sense that you get a kind of, you have to realize, I think, that the discussion of continuity, discontinuity, is related to this discussion of partiality, which is the political dimension of constitutional law associated with partisanship and disagreement, but at the same time impartiality, which has to do with structuring relatively acceptable by the other sides of the political game rules, which cannot satisfactorily be analyzed in legal constitutional terms, either as a process of substance as opposed to process, in the sense that, okay, the vote democratically, but if the majority decides to establish very unjust rules for the minority, rejecting the rights of the minority, then the minority, of course, will not accept, because it will not provide the consensus, nor in terms of the distinction, the divide between law and politics in a formalistic manner, somehow assuming that you can have a two description of the facts of the situation in order to subsume somehow at some point the crisis as a case of emergency or non-emergency, etc. These are open to interpretation. These have political roots, and at the very end, there is the only basic point with which I don't agree in Patrick's presentation of my paper. I don't think that this is at all a case of Bocconian analysis. It is Bocconian in the sense that it is ethico-political. It has ethical dimension. But it is not Bocconian in the sense of recognizing the monopoly or the priority of the Haitian judge who somehow applies principles. This is much more a kind of discursive element, a discursive situation. The reason that I mentioned in this FATIH, practical reason and Hobbes, is because his view is such a fascinating view in rejecting the possibility of the practical reason culminating in through deliberation in somehow useful solutions to the political problem of disagreement in society. So what he does is the well-known procedure of authorizing engaging our individual decision-making power and judgment to the judgment of the sovereign. But in our environment today, in modern constitutionalism, what we do is come down, I think, with this I finish, to some very basic understanding of the matter. I think that we all realize that if you want to have the minority participate in the rules of the democratic game and recognize the power of the judicial decisions instead of considering a sham or political trials beyond the one or the other, you have to recognize the fact that beyond political divisions, there is a common vulnerability associated with human rights and humanity, and a claim for respect and dignity. And unless you recognize them, then, of course, you can move on to models of political organization and political structure that will not include those who presumably want to live with you as your own citizens.
Thank you very much, Jonas. Well, we have several people online. Yes,
my question concerns your theoretical framework, your Hobbesian, Schmittian theoretical framework, because I did not really get the exact distinction between the silver rule and the golden rule. Maybe you can clarify that a little bit. And the question I ask is also why you do not take into account the platinum rule, so to say, the Kantian categorical imperatives, which is, I think, something distinct from the golden rule, and which is also a rule of impartiality. Because the act that I don't know I only know the German phrase of the categorical imperative. You have to act that the maxims of your action could be the maxims of some general legislation, something like that, which is categorically different from the golden rule, I suppose, because even the golden rule is rooted into self-interest. So you're not supposed to treat the other as you wish to be treated yourself. So you have, in the first place, you have to think about yourself. How do I want to be treated? And I think the difference in Kant is that which makes it a lot more complicated, because you have to. So you do not any longer act out of some sort of selfish self-interest. But you follow rules or maxims which are dictated by reason, something which is outside of yourself. And this is and then not Dworkin comes into play, but Rawls, who explicitly in the theory of justice, explicitly states that the theory of justice is a Kantian interpretation of justice. So, and then you have the constitutional mindset of drawn from this Rawlsian Kantian interpretation of impartiality rooted in reason, whatever reason is. I mean, that makes it complicated because nobody actually knows what reason is. But still, I think the Rawlsian conception is quite convincing.
Well, thank you for sharing this deeply understand. I have two questions. One, in regards to in page 2, how you describe that the hardest cases of emergency are those which arise out of fundamental political conflicts. And thus the challenge is to resolve these political conflicts by democratic means while preventing the dangers of emergency to materialize. And I was wondering what this understanding of a fundamental political conflict will be like in order to be able to discern when there is fundamental political conflict that justifies this. So this ways of decision making, extraordinary, if you will, decision making. Because as we heard from the previous presentation by Dr. Maitan, what happens when everything gets labeled as a political issue and that leaves out actors such as the judiciary, if I remember correctly. Insofar as if it gets labeled as a fundamental political issue, it might just be that they want to label it that way in order to prevent normal decision-making procedures. So I was wondering whether a more nuanced understanding or a more detailed explanation of what is understood by a fundamental political conflict could help in order to, in a factual situation, establish whether there is a fundamental political issue at stake. The second point regards also to the presentation yesterday about the outputs oriented legitimacy and legitimacy. This keeps coming up, and on page 7 you mentioned how much of constitutionalism's difficulty with necessity, exception, and protection of democracy comes from problematic or fallacious reasoning. Number 2, over the factual nature of constituent power legitimizing any effective elimination and replacement of a constitution as legally valid, regardless of how seizure of power had occurred. And then on section 7, you mentioned this, what you call the political voluntarism, and the notion, how the notion of constituent power doesn't work anymore to understand these political processes. So I was wondering whether this is related to what Andres was saying, that, okay, well, you see this as a problem where we don't pay any attention to how this seizure of power was made when the Constitution was created, which means they're only paying attention to the aftermath, to when the Constitution is already in place, and as long as it works, everything's fine, and we don't care about how we reached this point. Is that the claim then? Is that somehow what you see is that the inputs for how this constitutional procedure came into being is not important currently, and whether it should be more visible? Thank you.
Ricardo is calling.
I have no idea.
It's calling me too.
No, I have a question related to the sovereign debt crisis, because it is, in my view, different from all the other emergency you describe in your paper, because there is the supranational element to take into account. And don't you think that this element, the influence of the supranational international element, can challenge the narrative you pointed out in paragraph 9 about the role of the executive, parliament, and courts? So we have to take into account that we are in front of a parliament and an executive that are in some way constrained by the supranational level. So don't you think that this kind of emergency, the sovereign debt crisis, can challenge your narrative about the role of the separation of powers and of executives and parliaments and courts?
Thank you, Yaniv. Jonas, I really enjoyed reading this paper because it gave me a chance to learn about Greece. I don't know a lot about Greece and the Greek constitution. I want to ask about rules versus decisions. Rules versus decisions. The principle of impartiality, as I understand, to the rules that we have in place. So the rules have procedural dimensions, and they also have substantive dimensions. The decision that we make to get out of a emergency or out of a crisis, you can think of the decision as having an initiation and having an outcome. I don't think it maps on neatly to the input and output thought that we heard yesterday from Andreas and that we just heard echoed from Pedro. I don't think they map onto each other. I don't think it's inputs and outputs. I think it's separate. So the initiation of some process to make the decision and then the outcome of the decision. How do you understand the idea of impartiality when it comes to the decision itself? So impartiality as to the procedure of the rule in place, impartiality as to the substance of the rule. But what about as to the decision itself? Because we don't want impartiality when it comes to the decision. We want a positive outcome. And I want to ask the question a bit more specifically with regard to the referendum that we saw in Greece to decide what to do in the context of this financial emergency. The referendum itself is not an extraordinary tool. It's not an extraordinary device. But one might say that it was used extraordinarily in the Greek crisis. So how do we think of the impartiality principle when it comes to making the decision to get us out of the Greek financial crisis with recourse to the referendum? What kind of impartial norms do we need to have in place to initiate the decision-making process, the referendum, to get us to the right outcome, which is out of the Greek debt crisis? So it's not a particularly well-phrased question, except insofar as I'm trying to make sense through your paper of impartiality as it applies to rules, as it applies to the decision in the context of this extraordinary device of the referendum that was used to get Greek out of the crisis. Bracketing, of course, whether Greek might not still be in a crisis today.
Richard. I would also like to add 3 points of my own. First, we talked about the golden rule, silver rule. Now we're afraid to...
The platinum rule as well.
The platinum rule, and now I'm afraid to add on Vermeule. Vermeule has this paper on constitutionalism under the veil of ignorance, or constitutional rules under the veil of ignorance. And I think this could be very, very useful for the paper. Now, 2 other observations. One, how do you reconcile your rejection of Schmidt's decisionism with your, I think, implicit recognition of Jelinek's the normative craft, the normative power of the factual? I mean, once you agree that there is a point or power in Jelinek's claims, then you implicitly recognize Schmidt's decisionism, no? I mean, perhaps, I don't know, this is just something I'm struggling. And finally, I wasn't able to distinguish between constituent power in your paper and emergency power. For you, are these two similar? Because Farragon and Pasquino, they reject this, and they say these are not two similar things, so just things to think about.
I thought Pedro wanted to get in on something.
Well, just quickly, this referendum on the financial crisis was based on whether you consider this as an instance of a fundamental political issue, the way in which you are describing it on page 2. Most of my doubts.
So everything.
Yeah,
no.
Only 70%.
the questions and the comments. Let me first say something about impartiality. First of all, a general comment. I try to abide by the prescription of not writing over 10,000 words. So this is something which is a constraint, and I play by the rules. So forgive me for not for being very selective in terms of citations. Now, with regard to the question of impartiality, Professor Cunha also suspect that it's not here, but her spirit is in terms of being in the mood of smithing impartiality. And the analysis of impartiality is my analysis of impartiality. It's not Kantian, because Kantian Latin rule has different implications with regard to autonomy and the prudential nature. It is not consistent with the prudential nature of my analysis in terms of practical reason. So, this is the first thing. The second thing, which goes to Richard's point, is that the way that impartiality is associated with decisions is precisely the idea, which is the idea of the silver rule, of placing yourself in the other's shoes and doing this exchange, which is which Hobbes describes as the essence of natural law, of somehow mitigating solutions that wouldn't be acceptable from your perspective, were you in the other person's perspective. And this is a direction of
not only in our spirit. Next time, be careful what you wish for.
It's amazing.
Divine of solution to the emergency. Yeah.
Divine intervention.
So I was saying that and this version of impartiality eliminates, I think, the relation between rule as a pattern and decision, because there is it is against legal casuistry. Against decisionism is legal casuistry. Ad hoc, this uniqueness of each decision. What I think that is the whole thing is that when you have situations of emergency, you try to work on two different levels, and this brings the discussion to the issue of deep political leadership. On the one hand is to prevent, and there is the role of the executive, someone from really destroying the rules of the game, not as rules on the book, but rules in action. Institutions. You will not allow someone, because he challenges authority and he challenges the rules of the game, to actually proceed in bombing the parliament. But on the other hand, I think that it is part, and there is the practical implication of my analysis as opposed to the other views. I think that it is very important to accept that someone who is dissatisfied with the combination that the system, as an aid system, achieves between the impartiality of procedure, the procedural impartiality of the rules of the game, and the actual injustice, he has the right, because this means government by consent, to go out and say, I withdraw consent, and I think that the only solution is revolution. And of course, you will not allow him to implement revolution materialize it. But part of the idea is that we will have to achieve a level of common understanding so as to finally have him become part of the system. And this happens not in a compromise, which is not unprincipled. This is not Bocconi, it's practical. It has to be, it is Smithian. You have to read Smithian impartiality. You have to recognize and mitigate the harsh consequences for the weak part.
All right. So with that strong statement, I think we call it for the day. Allow me first to thank the participants in this panel. And while I'm already thanking people, so let me one more time thank the Minerva Center for the Rule of Law under extreme conditions for hosting this event, initiating this event, particularly Ricardo, Rahman, and Gadi, who's not here. And let me once again thank Michal and Lily for doing everything. And we have you and Richard, of course. And then, of course, I think we have a few more minutes. You want to talk about the book project?
Yes, yes. Let's.
Can I shortly say, on behalf of all of us, I guess, great thank you for you, Yaniv and Richard, for organizing the conference and for a really brilliant selection, composition of papers, posters, discussants. Thank you very much.
Thank you. So we have received a number of inquiries about the project going forward, and so this will be an opportunity to share with you our thoughts about how we'd like to proceed, and also field some questions and inquiries and take your input about how you might like us to take this project forward. But as a preliminary matter, let us lay out some of our thoughts, and these are thoughts that are subject to revision, if you like. But we've thought about this, and this is what we propose. So our plan is to seek to publish the papers in an edited collection with a reputable academic press. To do that, however, Yaniv and I will put together a proposal. To do that, in turn, we'll need the papers. So we won't actually submit the proposal until probably, depending on whether everyone submits their papers on time, whether the accompanying pieces are prepared on time as well. Probably February is when we hope publication of the book to maybe 3 reputable academic presses. And we won't submit them exclusively to a publisher. We'll submit them to 2 or 3 at the same time, and we'll alert them that we're doing that. But we propose that your revised papers be submitted to us, and we'll send you all of this stuff in an email, because there are some people who are not here right now. But December 1 is the date that we propose by which you send us your revised papers. 8,000 to 10,000 words, footnotes included. If some people would like some more space, we're happy to accommodate that. We'd like to talk with you first about that, though, because we wouldn't like imbalance among the papers. We'd like the papers to be similarly of similar length. So 8,000 to 10,000 words, footnotes included. We'll send you which citation conventions we'd like you to follow. OSCALA is what we'd like you to follow. All of the papers, will invite you to send them to someone in particular, but then we'll upload them on Dropbox. You now have the papers available, the drafts available on Dropbox. And in fact, we want to encourage you, as you're writing your drafts, to do some cross-citation. So now you know what the papers are like. They'll, of course, be revised between now and December, but we suspect that the core ideas in the papers will be there. And so we invite you to refer to those, to reference them in your revisions. That will strengthen the papers themselves. It will strengthen the collection itself and make it more attractive to the publisher when the time comes. When you submit your paper, we'll ask you to submit, of course, an abstract, along with a couple of answers to some other questions that we'll ask you to think about as well. But that will come up in the email that we send within the next 2 weeks. Two other things. Yaniv and I, in the next couple of weeks, will be thinking about how best to structure the book proposal. That is to say, what kind of categories the book will have. So the book is not going to be just all the papers thrown in. There'll be the papers grouped into 2 or 3, maybe 4 different parts, thematic parts. And this is the work that Yaniv and I will be doing in the days ahead about how best to structure the papers. We will also invite some of the discussants, to the extent they wish to participate in this way, to write mini introductions to these parts. So thematic introductions to each of the 3 or 4 parts, allowing the discussants, again, to the extent they wish, to draw connections among the papers and the parts that we will have identified, to critique the papers, to situate the papers in their own work, because the discussants, of course, have been invited to comment on the papers because they're experts in these questions, interested in these questions. And so to the extent anyone is interested in doing that, let us know. Again, this invitation will come out in the email that we send out in the next couple of weeks, but we iterate it, we convey it to you now in case you want to start thinking about it. The introduction should be, the mini introduction should be about 25 to 3,000 words. Not too short, not too long, but enough to say something of some interest and some substance. Yaniv and I will write an introduction and a conclusion to the book that will draw themes together from the papers, that will situate the papers themselves in the larger scholarship on emergency and crisis. And so we'll do that. We haven't yet decided whether who will write the intro, who will write the conclusion, but we'll talk about that. We hope to have Chief Justice Barak's remarks included in the book, either as a standalone chapter or perhaps as some kind of a foreword. So these are the things that we're thinking about. So once we get your papers December 1 or thereabouts, we will share those with the people who will be writing the mini introductions for each part. And then after we these things together, and then we'll ship them off to the publisher. One more point, and then questions and comments. All papers will be subject to peer review. This is something that will strengthen the collection, and there'll be 2 stages. There'll be some internal review, so we will give comments to the papers, but of course the publisher will review the papers themselves. And so not all papers may survive review. Yaniv and I, from our perspective, we want every paper to be included in the collection. And so we will give comments where we think is useful to strengthen the paper. But I think the real test will come when the publisher looks at the papers and may say, well, this paper is strong, this one is not so strong. And so it will be our task, Yaniv and I, to get the papers as strong as possible for when they go to the publisher. But you can rest assured that the papers will be peer reviewed, which I suspect you care about, and that your respective institutions care about as well. So with that, I'll pause for now, and happy to take some questions and hear some comments for both Yaniv and I.
Very short question: do you have a working title for the volume?
No, not yet. Perhaps yeah, okay. It's a working title.
What
but
is conference in Haifa? I remember.
yeah. But we want to make sure for indexing of books, it's very important that the book and not be too kind of fancy and too metaphorical. So I do think that the title of the symposium is very good, but we want to make sure that it's the best possible one that it could be. So we're not ready to commit yet to that, but. Yeah.
If you have any ideas, feel free to
Of course, yes, of course. No, there's no monopoly on great insights on titles here, so please, if you have any thoughts, let us know. Comments, questions? Journal.
Systems and very different ranking and communication assessments. Some systems application of journal counts much more than a book.
Counts much more.
Maybe German could be interested in that special volume.
Yeah.
Non-contemporary problems is a case in point.
So one, this is an alternative. The reason why Yaniv and I have suggested a book is because leading up to this symposium and in conversation with participants, people have said, "Oh, well, where is it going? Which publisher will publish it? It's going to be an edited volume." We haven't given much thought to a journal. I think we're both happy to revisit that if there's a sufficiently critical mass of people who would prefer that. The problem, however, not a problem, a challenge, would be that the number of papers is such that all the papers, it's unlikely that they're all going to fit in one journal. Now, I have in the past organized programs where there have been 16 to 20 papers, and we've had to work with 3 journals. And that's worked out fine. The journals are happy because they get good content. We are happy because we have a bit less work. We don't have to edit all the papers. We don't have to write an introduction. But we're sad because we don't get the benefit of having all the papers together in one collection. So there are pros and cons. So I think Yaniv and I are both happy to consider journals if that's something that people would like to talk about.
I think we also need to remember that as far as I know, there is no such book in the market. This could really be a unique book that deals with this idea of constitutionalism. Not, okay, there are some books about judicial review or, rights, but not on this particular theme. And, this might be unique, something in the market, unique product.
I think that's right.
Accessible. I mean, digital in a journal
you.